Please be seated, everyone.
And before we're going to adjourn for 1 second, we're going to have pictures taken by both teams. So plaintiff team, come up behind the judge. And pictures taken.
Squeeze in.
Thank you. Have a good one.
Your Honor, this is the case of Mans versus Towns. All counsel and parties are present.
Okay, good morning, everyone. All right, before we begin, I'm going to have counsel in the sidebar. Can all counsels come over on the sidebar? All right, good morning, everyone. Are the parties prepared to proceed this morning?
Yes, Your Honor. Good morning. My name is Henry Z. Heimerman, and I, along with my co-counsel, Sam Lockwood, morning, Your Honor, and Maria Triana, are representing the plaintiff this morning. We do have a few housekeeping matters to address.
Okay.
May we make our appearances for the record?
Yes, please.
And I do have a copy of our roster. Would you like that?
Yes, please. Thank you.
Thank you.
Your Honor, portraying Dalen Edwards will be Miss Nyla Hardy.
Good morning, Your Honor.
Good morning.
Portraying Dr. Leyton Manns will be Miss Rain Furkey.
Good morning, Your Honor.
Good morning.
And portraying Dr. Quincy Roberts will be Miss Anab Ali.
Good morning, Your Honor.
Good morning.
The plaintiff would also ask that all witnesses except the defendant and the plaintiff be constructively sequestered in accordance with Mock Trial Rule 11F.
Would the defense like to be heard on that matter?
That would be fine with us, Your Honor.
Okay, the application is granted.
And we would also like to pre-mark our exhibits in the interest of time.
That'll be great. Does the defense have any exhibits to be pre-marked?
Yes, Your Honor. Permission to approach.
You may approach.
The plaintiff is ready to proceed, Your Honor.
Okay.
It's all the same.
Okay, does the defense have any housekeeping matters they'd like to address with the court?
Yes, Your Honor. Before we begin, the defense would like to introduce itself and address a few pretrial matters. Permission to proceed.
Yes, you may.
On behalf of the defendant, Sandy Towns, I am Taylor Dickerson, and I am joined by my co-counsels, Calder Weiss.
Good morning, Your Honor.
And Alex Chambers-Trubach.
Good morning.
We've prepared a roster of our rules for your convenience. Would you want to like a copy?
That'd be great, thank you.
Permission to approach opposing counsel on the bench in turn.
Yes.
Permission to proceed with pretrial matters.
Yes, please.
Your Honor, it is our understanding that today's proceedings could be a jury trial. So although we understand that there is no jury here before us today, do we have Your Honor's permission to address Your Honor as both judge and jury solely for the sake of our statements?
Yes, you may.
Second, is it the court's preference that we ask Your Honor's permission before approaching the bench, opposing counsel, or witness?
Yes.
And third, Your Honor, the defense would like to request a brief recess after the plaintiff has rested their case and before closing statements.
That'll be fine.
With that, Your Honor, the defense is ready to begin.
Okay, great. It sounds like we're ready to proceed. Does the plaintiff have an opening statement?
Yes, Your Honor. Your Honor, may I proceed?
Yes, you may.
Good morning, Your Honor, and opposing counsel. My name is Sam Lockwood, and along with my co-counsel, Henry Z. Heimerman and Maria Triana, I have the honor of representing the plaintiff in this case, Dr. Leyton Manns. For over 30 years, Dr. Manns dedicated her life to serving Presiding as a teacher, administrator, superintendent, and county legislator. In 2024, Presiding was ready to send Dr. Manns to the state senate until the defendant, Sandy Towns, destroyed that opportunity. Towns had the agenda, anger over the elimination of the computer science club by Dr. Manns. Towns had the ability, technical skills in artificial intelligence, or AI. And Towns had the access, entry into the computer science club room, which housed technology capable of producing false, AI-generated recordings of a person's voice and or appearance, commonly known as deepfakes. Using their AI skills, the defendant fabricated 2 deepfakes, an audio recording appearing to show Dr. Manns making disparaging comments about the Athena High School community, as well as a video recording portraying Dr. Manns accepting a $50,000 bribe. The defendant then posted these recordings online, ensuring they went viral. Overnight, Dr. Manns' respected reputation was ruined, and her state senate campaign collapsed. 34 years of public service wiped away by just 2 calculated acts. In this defamation case, the plaintiff holds the burden of proof, meaning that we must show by a preponderance of the evidence that our claims are true. And should the court find that Dr. Manns is a public figure, we must prove by clear and convincing evidence that the defendant acted with actual malice. This case has also been bifurcated per stipulation 3, meaning that the sole purpose of this trial is to determine whether the defendant, Sandy Towns, defamed our client, Dr. Manns. Defamation, as defined in the C&B Healthcare Insurance Company, is a false statement that exposes a person to public contempt, ridicule, aversion, or disgrace. Your Honor, when you consider the extensive testimony and evidence, we hope that you will agree that Sandy Towns created and posted recordings of Dr. Manns that they knew were fake, meeting the burden of proof and defamation exactly. The plaintiff will call 3 witnesses. First, Dr. Manns, who will testify to the devastation caused by these deepfakes, as well as recounting previous encounters with the defendant, who openly resented them. Second, Professor Quincy Roberts, an expert in artificial intelligence, will testify to how the deepfakes could have been created and show why they likely originated from a computer that the defendant regularly accessed. Third, Dalen Edwards, a classmate of Towns's, will testify to seeing the defendant rushing out of the computer science club room just minutes before the initial deepfake was posted. The defense is also expected to call 3 witnesses: Sandy Towns, Fran Gates, and Jamie King. Towns is expected to deny involvement, but their actions and access tell a different story. Gates is expected to testify that minimal skills could have produced the deepfakes. However, their demonstrated bias and presented evidence implicate Towns. Third, Jamie King, a teacher of Towns's, is expected to concede that the defendant had the necessary technical skills to produce these deepfakes. Your Honor, Dr. Manns dedicated 34 years of her life to serving her community with integrity. Sandy Towns, fueled by a vendetta, forged in deception, turned a personal grudge into a digital weapon. Your Honor, the plaintiff requests that Sandy Towns be found liable for defamation. Thank you.
Thank you, counsel. Does the defense have an opening statement?
Yes, Your Honor. Permission to proceed?
Yes, you may.
Your Honor, members of the jury, may it please the court. Mr. Lockwood just told you that Sandy possessed the agenda, the ability, and the access to create these deepfakes. But today, you'll learn that those 3 traits could apply to anyone. The only reason we're in court today is because before the investigation had even begun, the plaintiff had already concluded that Sandy was the culprit. She picked Sandy from the start. Today, you'll meet Sandy Towns, a hard-working student with a bright future ahead of her. You'll learn that Sandy is a natural leader, someone who looks out for the well-being of her friends and classmates. You'll also learn that she was cooperative throughout the investigation. Despite this, the plaintiff has accused Sandy of creating defamatory deepfakes, when the only thing Sandy did was work tirelessly to protect her club. As the president-elect of the Computer Science Club, when Sandy learned that Superintendent Manns was cutting the club's funding in June of 2023, she scheduled a meeting, hoping to reach an agreement. You will learn that despite the plaintiff's hostile attitude, Sandy remained calm and composed, always working in the club's best interest. When Sandy denied involvement with the round of graphics that had been produced a year prior, the plaintiff wouldn't take no for an answer. He believed it was Sandy from the start. And when the deepfakes were released on April 1st and 2nd, the plaintiff immediately believed it was Sandy. He never considered for a moment that the many students he had angered with his sweeping budget cuts had created the deepfakes. For him, it was Sandy from the start. Now, let's take a moment to discuss what the law requires. The plaintiff, not the defense, bears the burden of proof in today's case. She must show by a preponderance of the evidence that Sandy committed liable. In other words, she must show that it is more likely than not that Sandy created the deepfakes, but she will fail to meet her burden. To shed light on the holes in the plaintiff's case, the defense will call for 3 witnesses. First, you'll hear from Sandy's AP Computer Science teacher and the faculty advisor for the Computer Science Club, Miss Jeannie King. She will explain that Sandy was not unique in her understanding of AI. In fact, Miss King teaches a college-level course filled with students capable of creating the deepfakes, including Jalen Edwards. Ms. King will also testify that the computer allegedly used to create the deepfakes is shared by all members of the Computer Science Club, not just Sandy. Second, you'll hear from the technology advisor for the Helios School District and an expert in computer science, Mr. Fran Gates. He will testify that the VPN the plaintiff thinks is a slam-dunk piece of evidence connecting Sandy to the deepfakes is actually commonly used by high schoolers and can be easily downloaded and uninstalled. Third and most importantly, you'll hear from Sandy Towns herself. She will express her strong opposition to the unethical use of AI. She will also testify that at her meeting with the plaintiff fixated on a set of graphics Sandy had no involvement in. When Sandy expressed that she had no idea who created the graphics, the plaintiff leveraged her financial authority, withholding the club's funding in retaliation. Sandy will also tell you that she was not alone in her dislike of the plaintiff. The plaintiff's budget cuts angered everyone, including all members of the Computer Science Club. You will learn that despite this, the plaintiff's expert, Dr. Roberts, didn't investigate any of these other students, even though they similarly disliked the plaintiff and were proficient in AI. That's because the plaintiff was laser-focused on Sandy from the start. So what was unique about Sandy? Well, the fact that she dared to challenge the plaintiff's decision and had recently inherited $2 million. That's why, for the plaintiff, it was Sandy from the start. As a result, you'll learn that the plaintiff's expert, Dr. Roberts, didn't consider for even a second that Jalen Edwards, skilled in AI and a sworn enemy of Sandy, created the deepfakes to train Sandy. You'll learn that the plaintiff's expert didn't investigate a single computer besides the one computer room, even though the only thing supposedly unique about that computer was that it contained a VPN their own witness will tell you is commonly used by high schoolers. Members of the jury, there are simply too many stones unturned. The plaintiff's belief that it was Sandy caused her to neglect all other possibilities. Don't let the plaintiff's unjust bias take away Sandy's promising future. At the end of today's proceedings, my co-counsel, Alex Schubach, will remind you that the plaintiff's investigation focused on Sandy from the start. The last thing on Sandy Towns, not live. Thank you.
Thank you. Okay, is the plaintiff prepared to call his first witness?
Yes, Your Honor. The plaintiff calls Dr. Leyton Mannix.
Yeah, I'm
Your Honor, may I proceed?
Yes, you may.
What is your name?
My name is Dr. Leyton Mans.
Where do you live, Dr. Mannix?
I live at 250 Harriman Way in Presiding, New York.
Now, how long have you lived in Presiding?
My roots run very deep. As I graduated from Athena High School, I attended SUNY at Presiding and then worked in the Helios School District for 34 years.
34 years? Well, Dr. Mannix, what were your roles in the district during that time?
I first worked as a teacher at Athena High School. Then, in 2004, I worked as the Assistant Superintendent for Finance and Personnel. Then, in 2006, I worked as the Superintendent for the Helios School District, where I stayed at for 17 years.
Did there come a time when you explored other career opportunities beyond the district?
Yes. In 2016, I ran and was elected for the county legislature.
How long did you serve?
I served for one term, 4 years, then was re-elected with over 70% of the vote.
Did there come a time when you explored further political opportunities?
Yes. In 2022, when the local state senator announced that they would not be seeking re-election, I decided to run for their seat.
And did you continue your work as superintendent throughout this campaign?
No, I retired, effective July 31st, 2023.
Now, Dr. Mans, what, if any, major responsibilities did you have in those final few months as superintendent?
My final major task was to finalize the school district's budget for the upcoming year of 2023 to 2024.
Okay, and what was the fiscal situation that year?
We were under very harsh conditions due to significant shortfalls in tax revenues, which led me to making cuts at many of the schools.
What cuts did you make?
Well, I had to lower the budgets of numerous programs in the district, even going as far as to cut one, the Computer Science Club at Athena.
Now, Dr. Mans, are you familiar with the defendant, Sandy Towns?
I am, yes. The defendant and I met in my office on June 20th to discuss the funding for the Computer Science Club.
Could you very briefly describe that meeting to the court?
Of course. During this meeting, the defendant asked me to restore funding for the Computer Science Club, voicing their opinion on it contributing to student success and college preparedness. I then voiced my concerns on the misuse of district resources.
You voiced your concerns. What were those concerns, Dr. Mans?
Well, in 2021, the members of the Computer Science Club had posted graphics about me online on district websites. And in my eyes, this is a clear misuse of district resources.
Now, you mentioned you told the defendant that. How did the defendant react to hear your concerns?
Well, after telling them that, in a halting voice, they said that they didn't even know about the graphics that were created, then turned around and claimed not to have any involvement in the graphics and did not know who was.
Now, Dr. Mans, did anything that the defendant said to you in your meeting change your mind about a funding decision?
No, I stuck with my previous budget, and I told them that.
How did the defendant react to hearing this news?
The defendant, before storming out of the meeting, said in a very hostile and threatening manner how a lot of students are being hurt by your actions, and situations like this don't always end very well.
Now, Dr. Mans, let's circle back to your state senate campaign. How did that campaign start off?
It started off great. I was up in the polls, and I was confident that I would win the seat.
And did that continue?
No, it didn't. My campaign went off the rails in early April when a fake video and a fake audio recording were posted about me online.
Your Honor, may I approach and retrieve Plaintiff 1 for identification?
Yes, you may.
May I approach the witness?
Yes, you may.
Dr. Mans, I'm hitting you with the marked Plaintiff 1 for identification. Do you recognize these images?
I do, yes. These are screenshots from the video recording posted on RickRock on April 1st at approximately 1 p.m., appearing to show me accepting a $50,000 bribe from a building contractor in order to build a new elementary school.
Your Honor, Stipulation 6 states that the screenshots in the screenshots exhibit are from the video posted on RickRock on April 1st, 2024, purporting to be an alleged bribery in progress. In light of this, we offer Plaintiff 1 in evidence at this time.
Any objections?
No objections, Your Honor.
All right, plaintiff 1 is in evidence.
Dr. Mans, did you actually have the conversation depicted in that video?
No, absolutely not. I would never take a bribe.
And were there any plans to build a new elementary school that year?
No, there were no plans to build a new elementary school in the 2023 to 2024 budget, and in fact, the school district hasn't built a new elementary school in 10 years due to the declining school age population.
Your Honor, may I approach and retrieve Plaintiff 2 for identification?
You may.
And may I approach the witness with this as well?
Yes, you may.
I'm now handing you what's been marked as Plaintiffs 2. Do you recognize this document?
Yes, I do. This is a partial transcript from the audio recording posted on SEDIT on April 2nd.
Your Honor, Stipulation 7 states that the words in the audio transcript were taken from the audio recording. In light of this, we offer Plaintiffs 2 in evidence at this time.
Any objection?
No objection, Your Honor.
All right, there being no objection, plaintiff 2 in evidence.
Dr. Mans, could you describe the audio recording to the court?
Of course, the audio recording has my voice making disparaging and disturbing comments about parents, students, teachers, principals, and others in the school district.
Dr. Mans, did you actually make those comments?
No, absolutely not.
Now, what happened as a result of the posting of the video and audio recordings?
The backlash against me was swift and relentless. On April 3rd, the Kronos Chronicle published a front-page story as well as a breaking news bulletin. Then, on April 7th, the newspaper editorial board called upon me to exit the state senate race and resign from my position on the county legislature.
Now, did you take any action regarding the posting of the video and the audio?
I did, yes. On April 10th, I went to the sheriff's department and asked them to investigate the matter.
And in the meantime, what happened to your state senate campaign?
Due to all of the bad publicity, people just lost interest in helping my campaign. Campaign fundraising dried up. Paid staff had to be let go. Volunteers stopped showing up. And my campaign headquarters had to be shuttered in the late afternoon of April 30th, 2024.
You said April 30th. Did anything else of note happen on April 30th?
Yes, Professor Quincy Roberts released a report fully exonerating me, but it was already far too late to save my campaign.
Dr. Mans, beyond the state senate campaign, how did the posting of the video and audio recording impact you?
The publicity shattered my reputation. After living my entire life in Presiding.
Objection, Your Honor. Pursuant to Local Rule 201, the prejudicial effect of this testimony far outweighs its probative value. As opposing counsel said in opening statements, this is a bifurcated trial going to liability and not damages. This witness has already testified that her campaign was damaged by these deepfakes. Any further detail as to her emotional turmoil or other effects only serves to make the jury more sympathetic to Dr. Mans and has no substantive probative value.
Okay, counsel?
Your Honor, part of our responsibility this morning is to prove that Dr. Mans was harmed, and this goes to harm.
Okay, I'm going to overrule the objection. It's part of the cause of action.
My reputation was absolutely shattered. After living my entire life in Poseidon and giving 34 years of service to this community, my reputation was ruined, my legacy tarnished, and any hopes of further public service absolutely destroyed due to all 2 fake posts.
Thank you, Dr. Mans. Thank you, Your Honor. No further
Okay.
questions.
Any cross-examination?
Yes, Your Honor. Permission to proceed?
Yes, you may.
Good morning. I'd like to begin by discussing your campaign for state senate. In late 2023, your internal polling showed you had a double-digit lead in the primary.
That's correct.
You did not conduct any polls after that.
Objection, Your Honor. Counsel is asking the witness to invent fact.
Your Honor, may I respond?
Yes, you may.
This is a cross-examination. If the witness does not know the answer, she may say so. Furthermore, I'm not asking the witness to invent a fact outside her affidavit, but rather pointing to something that was pointedly not in her affidavit, and that absence, I'm pointing to that absence.
Okay, I'll give you some leeway. Overrule for now.
Dr. Mans, you did not conduct any polls after that.
We may have.
Dr. Mans, is it your testimony that you conducted more polls after the ones that you took in 2023?
We did, yes.
Dr. Mans, you made an affidavit for this case.
That's correct.
You signed that affidavit,
That's correct.
and you would recognize that affidavit if shown to you.
I would.
Let the record reflect that I'm holding a copy of Dr. Mans' affidavit. Would opposing counsel like a copy? Would Your Honor like a copy?
What's the purpose of showing her the affidavit?
I'm using this affidavit for impeachment purposes, Your Honor.
Okay, you can. We don't need to mark it. You can use it. Just hand it to the witness.
Yes, Your Honor.
Thank you.
Let the record reflect that I've handed the witness a copy of her affidavit. Dr. Mans, is this a fair and accurate copy of your affidavit?
It is, yes. I have 2 copies, by the way.
Is that your signature on the bottom line?
It is, yes.
And in this affidavit, you swore to tell the truth, the whole truth, and nothing but the truth.
Yes, I'm duly sworn.
Dr. Mans, nowhere in this affidavit did you say that you conducted polls in 2024.
Objection, Your Honor. Counsel is attempting to use the silence of the affidavit on the issue to assume a negative.
Overrule. Overrule.
Dr. Mans, I'll ask you a question. Nowhere in this affidavit did you say that you conducted any polls after 2023.
It doesn't say that I did not.
That's not my question, Dr. Mans. My question is, did you conduct polls after 2023 that showed you how to lead in the primary and neglect to put that information in your affidavit?
Objection asked and answered, Your Honor. As counsel reminded us, she asked a question to which the answer was not in the affidavit. And as counsel reminded us, the witness is entitled to make up an answer to that question.
Your Honor, may I respond?
You may.
The asked and answered objection, I'm simply asking for this witness to clarify her answer. Furthermore, pursuant to local rules, if a witness is asked a question outside the scope of their affidavit, they may not invent a fact that materially alters the outcome of the case. The damage done to Dr. Mans' campaign is a key issue in today's case, and any invention as to whether or not that campaign was doing better or worse in 2024 materially alters the outcome of the case. Furthermore, that does not interfere with this impeachment.
The second question was a little different than your original question, so I'm still going to give you a little leeway. Overrule for now.
So, Dr. Mans, after reviewing this affidavit, is it your testimony that you conducted polls in 2024?
I was trending upwards, and I didn't believe I had to.
I'd like to talk now about your relationship with your would-be constituents. Dr. Mans, you're a public figure,
I believe I would be, yes.
and even before you ran for state senate, you were highly involved in your community.
I apologize, Your Honor. I asked that the last question and answer be stricken from the record as it goes to the ultimate issue of the case.
Your Honor,
Counsel?
may I respond?
Issue?
This is within this witness's rational perception as to know whether or not she was a public figure, and she can testify to that.
I'm going to overrule it. That's one of the elements that we have to discuss in this case.
Dr. Mans, as superintendent, you interacted with students and teachers often.
Yes, that was my favorite part of the job.
You felt that you needed to be a disciplinarian.
A fair disciplinary, with also keeping a smile and an open door for anyone.
To bring you back to my question, you felt that you needed to be a disciplinarian,
Yes,
and many of your decisions weren't well received.
as doing budgets, no, they were not always well received.
Many students didn't like you.
I don't believe that to be so.
Well, needless to say, as a budget director, you don't make many friends.
I believe that any budget director would say yes. You don't make many friends because you have to say no sometimes. But I believe I was well liked.
Dr. Mans, I'm asking about you. As a budget director, you don't make many friends.
I believe I was well liked. But yes.
Let's talk about the real reason why you're here, Dr. Mans. In 2021, members of the Computer Science Club at Athena High School began posting insulting graphics about you.
Yes, in June of 2021.
These graphics did not upset you at first.
No, they didn't.
But over time, they started to bother you.
The graphics became increasingly vile and crude, and they kept reappearing month and month after month, so they did bother me.
You felt that these images were disgusting.
Yes, I did.
You felt that they were tasteless.
I did, yes.
You felt personally ridiculed by the members of the Computer Science Club.
These graphics were very crude and vile, and I felt like I was being misrepresented.
Let's move to the budget you made a year after these graphics stopped being released. Dr. Mans, you resigned as school superintendent in 2023,
Yes, to fully focus on my state senate campaign.
but you were still responsible for making the school budget for the 2023 to 2024 academic year.
That was my final task as superintendent, yes.
You had to make significant cuts at many schools.
There were significant shortfalls in tax revenues, and there was a poor economy at the time, which led me to making cuts at schools.
You made small cuts to many programs,
I made cuts to many programs.
but you cut funding for the Computer Science Club completely.
That's correct.
And Dr. Mans, to be clear, the Computer Science Club was the only club whose funding you completely cut.
There were cuts around the district, but yes.
And you felt perfectly justified in making that decision.
I did. The graphics were a clear misuse of district resources, which led me to making these cuts.
And to be clear, you felt justified because about those graphics that were made about you.
Yes, these graphics were made about me, but the club can't just make graphics. That's not in what the club is supposed to do.
Let's move to June 20th, 2023. That day, you met with Sandy Towns.
Yes, the defendant and I met in my office.
You met to discuss restoring funding to the Computer Science Club.
That was the purpose of the meeting.
But Dr. Mans, that's not all you talked about, is it?
No.
You asked Sandy for the names of the students involved in posting the graphics about you.
I was looking for who was responsible, yes.
Sandy told you she didn't know who was involved.
The defendant first claimed not even to know about the graphics that were posted, then haltingly said she did not know who was involved.
She said she wasn't involved in making the graphics.
That's correct.
And she asked what the graphics had to do with funding for the Computer Science Club.
That's correct. But there is a direct correlation between the graphics being produced as a misuse of district resources and the cutting of the Computer Science Club.
Well, let's be clear about what you said in response to her then. In response, you called her a miscreant.
In the heat of the moment, I may have said this.
You said you and your cohorts should have thought about that before posting those graphics.
Yes, I did say this.
You said that there would be no funding for the Computer Science Club under your watch.
That's correct.
So Dr. Mans, just to be clear, you did not restore funding for the Computer Science Club in your budget proposal?
No, I stuck with my previous budget.
You finalized that proposal on June 30th?
Yes, after it was reviewed by the school board, and they had approved it with 0 changes.
When that happened, you were happy to see that the Computer Science Club's funding had not been restored.
I was happy that the school board had agreed with my decision.
But to be clear, Dr. Mans, you would say it's happy that the Computer Science Club's funding was not restored.
I was happy that everyone agreed with me, yes.
Dr. Mans, I'd like to focus you on my question specifically. I'm asking about the Computer Science Club funding. Happily, the Computer Science Club's funding was not restored, right?
Yes.
I'd like to talk now about your relationship with Sandy specifically. Dr. Mans, the moment you saw the deepfake video and the audio recording, you blamed Sandy.
I believe that the defendant was the culprit of who made the video and the audio.
That's because you've had a problem with Sandy for years.
No,
Is it your testimony that you have not had a problem with Sandy for years?
My problem started in 2021.
So yes, that's a yes to my question. You've had a problem with Sandy for years?
I guess so.
You think Sandy is devious?
Some would say.
What you would say, right?
Perhaps.
You think Sandy is self-serving?
Yes.
You think Sandy's a miscreant?
I personally said those in the heat of the moment.
You think Sandy is a smarty pants brat?
I believe that I said some harsh words in that time.
Dr. Mans, I'd like to direct you to my question specifically. You believe that Sandy is a smarty pants brat.
I may.
You're aware that Sandy recently came into a $2 million inheritance?
I have grown aware of that now.
You look forward to receiving a big chunk of that money.
After everything that has happened to me, my reputation, my legacy, and my state Senate campaign, I believe I deserve fair compensation.
That's not my question, Dr. Mans. My question is, do you look forward to receiving a big chunk of that money?
As compensation.
Thank you, Your Honor. No further questions.
Okay, thank you, counsel. Do you have any redirect?
Yes, Your Honor. Dr. Mans, were you the only one responsible for the budget of the 23-24 school year?
No, I wasn't.
Who else?
I had an assistant budget director.
And did you send your budget to anyone for approval?
I did. The entire school board so that they could approve my decisions.
No further questions, Your Honor.
Okay, thank you. Any recross?
No recourse, Your Honor.
Okay, thank you.
Thank you.
Just give me 1 second.
Do you want this?
And give it to the clerk.
Thank you.
Does the plaintiff have any more witnesses?
Yes, Your Honor. The plaintiff calls Dr. Quincy Roberts.
Now raise your right hand, and do you promise to tell the truth?
Yes, I do.
Please have a seat in the box.
Good morning, Your Honor.
Good morning.
May I proceed, Your Honor?
Yes, you may.
Good morning. What is your name?
My name is Dr. Quincy Roberts.
And Dr. Roberts, how old are you?
I'm 46 years old.
What is your occupation?
I am a professor of computer science at the State University of New York at Presiding.
You mentioned computer science. What is your educational background?
I have a bachelor's degree in mathematics from New York University in 2000. I then later got my master's in mechanical engineering and then my PhD in computer science, both from Columbia University.
And did you write a thesis for your PhD?
Yes, I did.
What was the subject of your thesis?
It was on theoretical analysis of artificial intelligence, or AI, in human technologies.
And Dr. Roberts, you're a professor. What are your responsibilities in that job?
I conduct academic research and teach at the graduate level.
And what are the areas of study that you focus on?
I cover many aspects of artificial intelligence, including task division, algorithm game theory, and distributive AI.
Have you published any books in your area of expertise?
Yes, I've written 2 books. My first book was on artificial intelligence, the future of machine learning, and my next book was on forensics AI.
Have you spoken about artificial intelligence at professional conferences?
Yes, I've spoken in numerous computer technology conferences on the benefits and hazards of artificial intelligence.
Dr. Roberts, have you testified in court cases?
Yes, I have. I've testified in both state and federal court cases, 5 to 6 times in the last 7 years.
Your Honor, in accordance with Your Honor, based on her educational background and her professional experience, the plaintiff requests that Dr. Roberts be certified as an expert witness in computer science and artificial intelligence.
Any objections?
Permission to voir dire the witness, Your Honor.
You may.
Dr. Roberts, you are not an investigator, correct?
That is correct.
You have not received education in investigative processes.
That is correct.
You have not received training in investigative processes.
That is correct, but I was hired to investigate whether the video and audio recordings were deepfakes.
Your Honor, while the defense does not object to the entering of this witness as an expert in AI, we anticipate that this witness may try to offer testimony to an investigation she purportedly conducted. To the extent that the witness offers such testimony, I'll re-raise my objection.
Okay, so I'm going to grant the application deemed as an expert witness.
Thank you, Your Honor. Dr. Roberts, how did you come to be involved in this case?
Because of my expertise in artificial intelligence, I was asked by the Kronos County Sheriff's Department and the county's crime lab to conduct an investigation on whether a video recording in which a video that appears to be Dr. Mann's accepting a $50,000 bribe is fake, and to also examine an audio recording in which the voice that sounds like Dr. Mann's making disparaging comments about people associated with Athena High School is fake as well.
And what materials, if any, did you have before starting your investigation?
I was given a flash drive that was confiscated from the defendant.
Your Honor, may I retrieve what has been marked as Plaintiff's 4 for identification?
You may.
May I approach the witness with this?
Yes.
Thank you.
Dr. Roberts, I have just handed you what has been marked as Plaintiff's Exhibit 4 for identification. Are you familiar with this item?
Yes, I am.
Could you identify it?
This is the flash drive I was given for starting my investigation.
Your Honor, in accordance with Stipulation 8, which states that that is the actual flash drive the district attorney's investigator confiscated from Sandy Towns, and that proper chain of custody was followed with the item, the plaintiff requests that Plaintiff's Exhibit 4 be received into evidence.
No objection to this exhibit being entered as Sandy's flash drive. If opposing counsel wishes to introduce this exhibit based on the contents, I ask that they lay additional foundation.
What's your purpose of entering this flash drive?
Your Honor, we are simply offering this for the fact that voices are recorded in the flash drive, not for the truth of anything asserted in that conversation.
Then I would like to raise a lack of foundation objection, as opposing counsel has not elicited testimony for how Dr. Roberts is aware of the contents of this flash drive.
I made it just for the limited purpose that it belonged to the defendant in this case. We'll see if additional foundation can be established. So it's actually the defendant's exhibit, correct? Not plaintiff's name. Plaintiff's 4, I think you said.
Plaintiff's 4, yes.
Defendant's. Oh, no, you plaintiff. I'm sorry, you're right.
Yeah.
Plaintiff's 4. Yes, I got confused.
Dr. Roberts, what, if anything, is on that flash drive?
The flash drive contains a recording of a conversation between the defendant and Dr.
Hold on.
Mann's.
There's an objection. When there's an objection, please stop your answer. What's the basis of your objection?
Lack of foundation. Opposing counsel has elicited no testimony as to how Dr. Roberts is aware of the contents of this flash drive.
I'll give her some leeway. Overrule.
May I re-ask my question?
Yes, you may.
Dr. Roberts, what, if anything, is on that flash drive?
The flash drive contains a conversation of a recording between Dr. Mann's and the defendant.
Objection hearsay. May I briefly explain, Your Honor?
Yes, you may.
The defense has a good faith belief that Dr. Roberts never reviewed the contents of this flash drive and is basing their understanding of the contents based on a conversation Dr. Roberts had with the Sheriff's Department. Therefore, the belief that this flash drive contains a recording of the plaintiff's voice is based on hearsay evidence and is therefore inadmissible.
Counsel, like to be heard?
Yes, Your Honor. This is not hearsay because we're not offering it for the truth of anything asserted in that conversation. Simply, that there are two voices in that recording and that Dr. Roberts used it in her investigation.
Okay, overruled.
Dr. Roberts, I would now like to direct your attention back to your investigation of the video and the audio. Did you examine the video recording?
Yes, I did.
And could you tell the court about the video?
I examined the facial expressions and body movements. The spoken words did not match up with Dr. Mann's lip movement.
And what did you conclude from this?
I determined to a high degree of scientific certainty that the video recording was an artificially generated deepfake.
Did you examine the audio recording as well?
Yes, I did.
Could you tell the court about it?
In the audio recording, the voice that is heard is slurred and rather flat.
And what did you conclude from that?
I also determined to a high degree of scientific certainty that the audio recording was an artificially generated deepfake.
Dr. Roberts, what is a deepfake?
Deepfakes are synthetic media, therefore, they're fake.
And how can one make one?
One would need generative artificial intelligence and machine learning capabilities to map these deepfakes.
Are there any materials that one would need?
Yes, one would need generative artificial intelligence algorithms to map these deepfakes.
Dr. Roberts, could you hold up Plaintiff's Exhibit 4 for the court? In your expert opinion, would the voices on that flash drive be enough to make such a deepfake?
Yes, most certainly.
Did you do anything else in respect to the video?
Yes, I did.
And did you do anything else in respect to the audio?
Yes, I did.
What was this, Dr. Roberts?
I examined the metadata associated with the video and audio recording.
And what did the metadata show?
The metadata showed that the video and audio recordings were created on a computer owned by the Helios School District. It also showed that it may have been created on a computer in the Computer Science Club room at Athena High School.
And what, if anything, did you conclude from that?
I can say with a reasonable degree of scientific certainty that the video and audio recordings were created in a computer in the Computer Science Club room.
What did you do next in your investigation?
I went to Athena High School and carefully examined the computer in the Computer Science Club room.
You mentioned that computer. What, if anything, did you find in that computer?
There were some trace files in the computer's trace hidden memory system folder linked to my secret VPN with the stamp date of April 2nd, 2024.
Are you familiar with My Secret VPN?
Yes, I am.
Could you tell the court about it?
My Secret VPN is a virtual private network that anyone trying to hide their identity may use. It is one of those free apps that is easy to download and uninstall, and it is also common amongst high schoolers and hackers.
And Dr. Roberts, what did you conclude upon finding the My Secret VPN trace files in that computer?
I can say with an absolute certainty that My Secret VPN was used on April 2nd of 2024 and probably on April 1st of 2024.
Okay, Councilman to be heard.
Your Honor, Dr. Roberts has been qualified as an expert witness, and we have laid the foundation that she was conducting an investigation. She is simply testifying to her conclusions on this finding.
May I briefly explain, Your Honor?
Yes.
This witness has testified that there were trace files indicating My Secret VPN usage on April 2nd. However, they have not laid a foundation for how they came to the conclusion that My Secret VPN was also used on April 2nd. There is inadequate foundation for this conclusion.
All right, let's go to the weight of the evidence. Overrule.
Would you like me to re-ask the question?
Yes, please.
Dr. Roberts, what did you conclude upon finding the My Secret VPN trace files in that computer?
I can say with an absolute certainty that My Secret VPN was used on April 2nd of 2024 and probably on April 1st of 2024.
Did you conclude anything else?
Yes, and I'm also fairly certain that the video and audio recordings were sent from a computer in the Computer Science Club room.
Did you do anything else in your investigation?
Yes, I read the paper that defendant had authored on generative AI for their AP computer course, and I was certainly impressed.
Objection, hearsay. May I briefly explain?
Yes, you may.
The witness is essentially testifying that they are aware of Sandy's AI capabilities based off of a paper they read. This is hearsay because the witness is assuming that the contents of this paper accurately depict how to create a deepfake, and therefore it is offering out-of-court statements for the truth of the matter.
Okay. Counsel, have you heard?
Yes, Your Honor. The witness has been qualified as an expert in computer science and artificial intelligence, and she is just giving her conclusions on just a paper. We're not offering it for the truth of the paper, simply for the truth of her conclusions on it.
Okay.
May I briefly respond, Your Honor?
Yes.
Dr. Roberts is concluding about Sandy's AI capabilities based off the paper they've read. Therefore, they are concluding that the contents of this paper are true and accurate descriptions of how to create a deepfake. Dr. Roberts is relying on the truth of Sandy's paper for this conclusion, and the paper is an out-of-court statement being offered for the truth of the matter and is therefore hearsay.
Okay. Again, it goes to the weight of the evidence. Expert witness can rely on outside material, so I'm going to overrule it.
May I re-ask my
Yes.
question?
Mm-hmm.
Dr. Roberts, what else did you do in your investigation?
I examined the paper that the defendant had wrote on generative AI for their AP computer course, and I was certainly impressed.
And what, if anything, did you conclude from reading that paper?
The defendant's expertise in generative AI is superior to many of the students I teach at university, and there's also no doubt in my mind that the defendant has the proficiency to produce the disturbing video and audio recordings.
No further questions, Your Honor. Thank you,
Okay,
Dr.
thank you.
Roberts.
Do we have any cross by the defense?
Yes, Your Honor. Permission to proceed?
Yes.
Good morning, Dr. Roberts.
Good morning.
I want to start by talking about something we discussed on the record. You've never reviewed the contents of the flash drive, correct?
That is correct, yes. But I was given the flash drive from the investigators, so correct.
So you're relying on the sheriff's conclusion that this flash drive contains a recording of the plaintiff's voice, correct?
It was confiscated from the defendant, so yes.
But you've never reviewed the flash drive yourself?
Objection, Your Honor. Asked and answered. And also, counsel is asking witness to invent fact.
May I respond?
Yes, you may.
I'm not asking the witness to invent fact. Rather, I'm pointing to the absence of facts in their affidavit that point to shortcomings in their investigation. Additionally, though I asked a similar question before, I'm simply asking the witness to clarify.
All right, overrule. I'm going to give you some leeway.
So you've never reviewed the contents of this flash drive?
No, but I am aware that the defendant's voice and the plaintiff's voice is in that video.
I want to turn to your conclusion that a VPN was used on April 2nd. In the course of your investigation, I want to turn to your conclusion that a VPN was used on April 1st. In the course of your investigation, you discovered trace files indicating my secret VPN usage on April 2nd, correct?
That is not correct. I found out that it was used on April 2nd and probably on April 1st.
Well, in your investigative report, you included no mention of trace files indicating VPN usage on the 1st, correct?
That is correct. That statement is correct, yes.
So there were no files indicating VPN usage on the 1st, correct?
That is correct, yes.
The third thing I want to talk about is your understanding of Sandy's AI capabilities. Your understanding of her capabilities is based off of the paper that you read, correct?
That is correct, yes.
This paper is not a step-by-step guide for creating deepfakes, correct?
It was, yes, I would believe so.
It's a holistic overview of creating deepfakes, correct?
That is correct, yes.
I want to turn to your investigation. So, in the course of your investigation, you visited Athena High School, correct?
Yes, on April 18th, correct.
Because data from the recordings suggested that they may have been produced there, correct?
I believe that it was, yes.
In reality, the data showed that the recordings were created on a Helios School District computer, correct?
And based on my investigation, I was able to locate that it was created at Athena High School.
I'm asking about the specific data. The data said that the recordings were created on a Helios School District computer, correct, Dr. Roberts?
No, that is not correct. Once I started my investigation at Athena High School, I found some trace files in the computer linking it to my secret VPN with the exact date that the video recording was posted.
Allow me to clarify. Before visiting Athena High School, the data that you had access to said that the recordings were created on a Helios School District computer, correct?
That statement is correct, yes.
There are many schools in the Helios School District?
That is correct, yes.
Yeah, in the course of your investigation, you investigated a single school.
My investigation led me to Athena High School, and that's where I went.
Is that a yes to my question that you focused on a single school?
No, that is not correct. I started my investigation broadly at the Helios School District and narrowed it down to Athena High School, so that's not correct.
Is it your testimony that you visited any schools besides Athena High?
Because my investigation led me to Athena High School.
So that's a yes to my question that the only school you visited was Athena High, correct?
That is correct, yes.
I want to turn to your time at Athena High School. At the high school, you focused on the computer in the computer club room, correct?
That is correct, yes.
There was no computer science data prior to examining the computer that pointed you towards that specific computer, correct?
That is correct, yes.
There are many computers at Athena High School?
That is correct, yes, I would believe so.
There are many computers in the school district?
That is correct, one would presume, yes.
Yet in the course of your investigation, you investigated a single computer, correct, Dr. Roberts?
Because I was the only computer in the computer science club room, and once I investigated, there were some trace files linking it to that exact date in which the video recording was posted.
You never investigated whether there were trace files on other computers at Athena High, correct?
That is correct, yes, because I was the only computer there.
But there were other computers at Athena High, correct?
Objection, Your Honor, as the answer.
Overrule.
There were other computers at Athena High?
Correct, yes.
And you never investigated as to whether there were VPN trace files on these other computers, correct?
Once I started my investigation at Athena High School on April 18th of 2024 in the computer science club room, there was only one computer. So I investigated that computer and found trace files linking it to that exact same date.
Is that a yes to my question that in the course of your investigation, there were no other computers you investigated for trace files?
As I answered, yes.
I want to turn to that specific computer, specifically who had access to it. Sandy Towns is not the only person who used that computer, correct?
I would believe so, yes.
The entire computer science lab has access to that computer.
That is correct, yes.
Yet in the course of your investigation, you didn't investigate any of these other students.
That is correct, yes.
In fact, you didn't interview a single student in the course of your investigation.
Nor did I interview Sandy Towns.
Exactly, you didn't interview Sandy Towns before claiming that she's capable of creating a deepfake?
I read her paper, and it showed that she has the proficiency to produce their disturbing video and audio recordings.
A paper that we've agreed is a holistic analysis of the advantages and disadvantages of AI.
And it also showed that the step-by-step of creating a deepfake.
Is it your testimony that she shows how to create a deepfake step by step and creates one within this paper?
I don't understand what you're saying.
Does Sandy show step by step how to create a deepfake and do so within this paper?
Yes, she does.
I want to talk about the accessibility of my secret VPN. On the computer in the computer room, you discovered trace files indicating my secret VPN usage, correct?
That is correct, yes.
Because of this, you are sure that that computer was used to create the deepfakes, correct?
There were some trace files linking it to my secret VPN, so I used my scientific knowledge to presume that it did, yes.
Even though my secret VPN is commonly used by high schoolers?
And hackers as well, correct.
That's a yes to my question?
As I said, correct.
It's easy to download?
Correct.
Easy to uninstall?
Correct.
Yet the existence of that VPN makes you believe that computer was used to create deepfakes.
That is correct, yes.
I want to talk about why someone uses VPN. VPNs are used to obscure a person's identity, correct?
That is correct, yes.
To obscure what a person is doing.
Yes, so it wouldn't be traced back to them, correct.
You have no way of knowing if the deepfakes that were posted on that computer were also created on that computer, correct?
I presume that it was, so no.
But you have no way of conclusively knowing that the deepfakes that were allegedly created were also produced on that computer, correct?
That is correct, yes.
You have no way of knowing if the deepfakes were already on that computer, correct?
Because someone would have already deleted it, correct.
You have no way of knowing if someone brought the deepfakes to that computer via CD, correct?
That is correct, yes.
You have no way of knowing if the deepfakes were sent to that computer from someone else entirely via email, correct?
That is correct.
All you know is that a VPN was used on April 2nd, correct?
No, that is not correct. My investigation led me to believe that the video and audio recordings were created on that computer because there were some trace files linking it to that exact same date, and I used my scientific knowledge to believe that it was also created on April 1st of 2024.
To clarify, that VPN obscures what's going on that computer, correct?
That is correct, yes.
I want to turn to the reason you're here testifying against Sandy Towns today. You established a business with Sandy's granduncle, Jeff Tezos, correct?
Yes.
Just before going public in 2005, Jeff Tezos nudged you out of the business, correct?
That is not correct. It was 2004.
And because you left that business, you lost out on the opportunity to make millions of dollars, correct?
Unfortunately, I did. I worked so hard to help Amazon grow, and I was just nudged out.
And you were incredibly mad about the fact that you lost out on that money, correct?
Who wouldn't be?
And you believe that Jeff didn't consider the consequences of his actions.
No, he did not. He let me go in just a snap of a finger. I did so much to help Amazon grow with him.
Well, you believe that there are some similarities between Jeff and Sandy's behavior, correct?
They are related, so yes.
You believe Sandy doesn't fall far from the tree?
Again, they are related, so yes.
And you don't think we need another generation of selfish, entitled people who think they can do whatever they want to others, correct?
I don't think any generation needs that.
Is that a yes to my question, Dr. Roberts?
Yes, that is correct.
Thank you. No further questions.
Okay, thank you. You have any redirect? Yes.
May I proceed?
Yes, you may.
Dr. Roberts, how, if at all, does your payment depend on the outcome of this case?
Not at all.
And when were you nudged out from Amazon?
Objection outside of the scope of cross-examination.
Counsel?
Your Honor, counsel opened the door by speaking of money in their cross-examination.
I agree. Overrule.
Dr. Roberts, when were you nudged out from Amazon?
On April in 2004.
And how, if at all, did your history with Jeff Tezos influence your testimony this afternoon?
Not at all. I would not hold a grudge against somebody who's already deceased.
Thank you, Dr. Roberts. No further questions.
Okay. Any recross?
Yes, Your Honor, briefly.
Okay.
To clarify, Dr. Roberts, you are very mad that you lost out on the chance to make that money, correct?
Who wouldn't be? I worked so hard to grow Amazon, and I was just nudged out.
Thank you, Your Honor. No further questions.
Okay. Thank you.
Thank you, Your Honor.
Does the plaintiff have any more witnesses?
The plaintiff calls Leyton Edwards.
Raise your right hand, and do you promise to tell?
I do.
Please have a seat.
Thank you.
Your Honor, may I proceed?
You may.
Good afternoon, Miss Edwards. Could you please state your full name?
Yes, my name is Leyton Edwards.
And how old are you, Miss Edwards?
I am 19 years old.
Are you currently enrolled in school?
Yes, currently I'm a freshman at Kronos County Community College.
Okay, so you're in college. Before that, where did you attend high school?
I attended and graduated from Athena High School.
And when did you graduate?
That was in June of 2024.
During your time in high school, were you involved in any extracurricular activities?
Yes, I was a proud member of the Computer Science Club.
And how long were you involved with that club?
I was a member for 3 years, my freshman, sophomore, and junior year.
In those 3 years, did you hold any leadership positions?
I did, yes. My freshman year, from 2020 to 2021, I served as treasurer and then as secretary the following year.
Do you know the defendant, Sandy Towns?
I do, yes.
So how do you know the defendant?
Well, Sandy was my classmate at Athena and was also a member of the Computer Science Club.
Are you familiar with the plaintiff, Dr. Mans?
Yes, I am.
And how do you know Dr. Mans?
Dr. Manns was a superintendent while I was a student at Athena and also served as a county legislator.
Going back to the computer science club, did that club still exist your senior year of high school?
No, it did not, as the budget was cut by Dr. Manns in 2023.
I'd like to direct your attention to October of 2021. Do you recall whether or not you saw the defendant in the computer science club room at that time?
I did, yes.
And do you recall what they were doing?
Yes. I saw Sandy making computer graphics poking fun at Dr. Manns.
And about those graphics, did you say anything to the defendant?
Yes. I told Sandy that I did not find the graphics clever or funny.
How did the defendant respond to that?
She just shrugged it off and told me I should go away and mind my own business.
Did those graphics continue being produced?
They did. And as time went on, they became increasingly crude and vile.
I'd like to focus on events from June of 2023. Are you familiar with the app QuickChat?
Yes, I am. I use QuickChat. It's a popular social media messaging app known and used because it deletes the content after 24 hours.
In late June of 2023, did you see any QuickChat messages regarding the computer science club?
Yes, I saw one message from the defendant.
To whom was that message addressed to?
It was addressed to the executive committee of the Computer Science Club at that time, but I myself received a copy of that message.
And Miss Edwards, do you remember the content of that message you received?
Yes. Sandy said that there might be some nice Rick Rock videos released about the superintendent in the near future, and maybe even some juicy audio recordings.
Objection, hearsay.
Your Honor, if I may, this is admissible under two exceptions to hearsay: admission by a party opponent, Rule 402, and state of mind, Rule 403.
Okay, I agree.
Your Honor, offenders.
I agree. Overrule.
I'll re-ask my question, Ms. Edwards. Do you recall the content of that message?
Yes. Sandy said that there might be some nice Rick Rock videos released about the superintendent in the near future, and maybe even some juicy audio recordings.
Can you recall anything else the defendant stated in that message?
Yes. There was another statement to the effect that no one would vote for Manns after seeing the Rick Rock video and hearing the Senate recording.
Let's talk more about your high school career. Did you take any courses related to computer science?
Yes. My junior year, I took advanced placement computer science.
And who taught that advanced placement computer science course?
Miss Jamie King.
Did you have any other connections with Miss King?
Yes. She was also the advisor of our computer science club.
Did you complete a paper for AP Computer Science?
I did, yes.
And what was that paper about?
It was on generative AI.
Do you know whether the defendant wrote a paper on this topic?
Yes, she did. She received an A+ and would constantly brag about not only that grade, but how well she understood generative AI.
Let's talk about events from early April of 2024. On April 1st of that year, did anything happen relating to Dr. Manns?
Yes. I saw a Rick Rock video posted appearing to show Dr. Manns accepting a bribe from a building contractor.
Your Honor, may I approach and retrieve plaintiff's witness?
You may.
Your Honor, may I approach the witness?
You may.
Ms. Edwards, I've handed you Plaintiff's Exhibit 1.
Thank you.
Do you recognize these?
Yes. These are screenshots from the Rick Rock video posted of Dr. Manns.
You can set those aside now. Turning to April 2nd, 2024, did anything happen regarding Dr. Manns?
Yes. I heard a set recording of Dr. Mann's voice making disparaging comments about members of Athena High School and others associated with Athena High School.
Your Honor, may I approach and retrieve Plaintiff's 2? You may. Your Honor, may I approach the witness?
You may.
I thank you, Plaintiff's Exhibit 2. Do you recognize this?
Wait, I don't think this is the right thing. This is the paper.
It's the audio transcript.
I'll let you go for it.
Your Honor, may I approach the witness?
You may.
Now, thank you, Plaintiff's Exhibit 2.
Thank you.
Do you know what this is?
Yes, this is a partial transcript of the audio recording posted to Senate.
You can set that aside now.
Thank you.
Going back to April 1st of 2024, were you at school that day?
Yes, I was.
And did you have a school lunch period?
I did, at 12 o'clock noon.
Do you know whether the defendant had a lunch period that day?
Yes, she did, at the same time.
And did you see the defendant in the lunchroom on that day?
No, I did not.
Did you see the defendant at any point during that day?
Yes. At 12:55 p.m., I saw Sandy rushing out of the computer lab.
Okay, can you tell the court more about that interaction?
Sure. I saw Sandy rushing out, and she asked me what time it was, to which I said it was 12:55. And I tried to make a little conversation, but she told me that she did not have time to talk, as she was in a rush to get to her 1 p.m. calculus class.
Let's talk about events from April 8th of 2024. What, if anything, related to this case happened on that day?
I reached out to the sheriff's office.
Did you speak to anyone there?
I did. I spoke to the sheriff's investigator.
And Miss Edwards, what did you tell that investigator?
I told the investigator about the graphics that I saw Sandy creating and about the quick chat message I received from the defendant.
Thank you, Miss Edwards. No further questions, Your Honor.
Okay, any cross?
Yes, Your Honor. Permission to proceed?
You may.
Good morning, Ms. Edwards.
Good morning.
I'd like to start by talking about your time at the Computer Science Club. Now, you ran for vice president of that club in your junior year, right?
I did, yes.
And you lost that election to Sandy Towns.
Yes, due to the promises that they made that they never upheld.
Well, you believe you deserved to win that election, right?
I served that club for 2 years. So yes,
In fact, you think that Sandy stole that election from you.
I do. They made promises like field trips and faster computers that they could not keep.
You believe that had you won that election, you would have been guaranteed a full ride scholarship to your dream school. Isn't that right?
I believe I would have gotten a scholarship, but I'm not an admissions officer, so I'm not sure what the outcome would have been.
But you, Ms. Edwards, believe that it would have guaranteed you a spot.
I believe that I would have gotten a scholarship, yes.
And you didn't get that scholarship.
No, I did not.
And you think Sandy Towns won this.
I believe that had I won the election, I might have had a better chance, yes.
But you think Sandy Towns, for you not getting that scholarship?
Objection asked and answered.
Overrule. I'll allow it.
Sorry, can you repeat that?
And you blame Sandy, sorry. You think Sandy Towns for you not getting that scholarship?
Yes.
Now I want to talk a little bit more about the deepfakes themselves. You saw the first video on Rick Rock on April 1st, right?
Yes, I did.
And a day later on Senate, you heard the audio recording.
Yes.
You were sure that they were deepfakes.
After hearing the Senate recording, I was sure they were deepfakes. But initially, I thought it was just an April Fool's prank.
And after realizing they were deepfakes, you reached out to the county sheriff's office, right?
After a few steps, yes.
So I want to talk about your involvement in that investigation. Now you reached out on April 8th, is that correct?
I did, after seeing the Kronos Chronicle editorial.
They didn't reach out to you.
No, I reached out.
You informed them that the deepfakes were in fact deepfakes.
I told them that I believed that they were deepfakes.
And you learned they intended to investigate the computer in the computer clubroom.
That is correct, yes.
And it was upon learning this that you happened to remember seeing Sandy in that room on April 1st.
After spending several days thinking about the deepfakes posted of Dr. Manns, yes.
But it was upon learning that they were going to investigate that room. Is that correct?
That is correct, yes.
Now, that would mean that you were also within the vicinity of the room on April 1st?
I was, yes.
Now I want to talk about some other things that you informed the investigator. Now, sometime in late June of 2023, you claim to have received a message from Sandy, right?
I did, yes.
And do you remember the exact date that message was sent?
I remember it was sometime in late June, just before the school year ended.
So you don't have an exact date?
No, I do not.
You only remembered that message several days after you'd seen the deepfakes?
Again, after thinking of the deepfakes posted for several days, yes.
This was a year later?
I believe it was about 10 months.
And you didn't bring a copy of that message here to court today?
As I said, messages on QuickChat automatically delete after 24 hours.
And you didn't think this copy of message that you claim was threatening Dr. Mans?
At the time, I thought it was just towns blowing off steam, and I did not think they would actually go through with it.
Right. You didn't think Sandy would do anything.
At that time, no, but now I do.
Now, you also told the investigator about seeing a group of students, including the defendant, making graphics and poking fun at Dr. Mans. Is that right?
That is correct, yes.
And you claim to have seen this in October of 2021?
Yes.
But that October, you didn't report this to any authorities?
I knew that I did not want the club to be cut due to town's foolish actions.
To be clear, funding was cut in 2023. Is that right?
That is correct. But I knew that there would be consequences to the club, and I did not want anything bad to happen to the club due to town's foolish actions.
Ms. Edwards, the funding was cut and the club was shut down in 2023, right?
That is correct, yes.
And you didn't report any of this until 2024. Is that right?
When it became extremely important to what was going on.
You reported this to the authorities you reached out to?
The sheriff's department, yes.
Now, just to be clear, Ms. Edwards, you don't know exactly who made the graphics, do you?
What graphics? Sorry.
The graphics poking fun at Dr. Mans.
Wait, can you repeat that? Sorry.
Ms. Edwards, you don't know exactly who made the graphics poking fun at Dr. Mans.
I saw Sandy Towns making them.
Well, you don't remember a single other student that you claim was making them with her?
No, I do not. Just I remember Sandy Towns.
Now, I want to talk about the class that you shared with Sandy. You and Sandy took the same AP computer science course, right?
We did, junior year.
Ms. King's class?
Yes.
And in this course, you believe she showed a mastery of generative AI?
Sandy Towns?
Yes.
Yes.
To be clear, Ms. King, you also, withdrawn. To be clear, Ms. Edwards, you also took this course.
I did, yes.
You completed it.
I did.
It's a college level course.
That is correct.
You also wrote an essay on generative AI.
I did, yes.
And you'd agree with me that your essay was exceptional.
I believed my essay was very impressive, but I received a B-, which I don't think others would consider to be impressive.
But you'd agree it was exceptional.
I think it was impressive.
And now, Ms. Edwards, I want to talk about why you're here testifying today. Dr. Mans is your favorite superintendent, isn't she?
That is correct, yes.
You didn't like that other students were making fun of her.
I don't think that anybody should be made fun of in that manner.
And you blame Sandy Towns for what happened to your favorite superintendent.
I believe that Sandy Towns was fully capable of making those deepfakes portraying Dr. Mans.
Ms. Edwards, that wasn't my question. You blame Sandy Towns for what happened to your favorite superintendent, correct?
By making those deepfakes and defaming their character, yes.
But Ms. Edwards, you would say that you've moved on from your dislike of Sandy?
Of course, yes, I have.
You would also say that you believe what Sandy has done is unforgivable.
I believe that making graphics maliciously with intent to harm someone, yes.
And you believe that Sandy is selfish?
I do, yes.
You believe that Sandy is arrogant?
I did say that, yes.
You still call Sandy a know-it-all?
A know-it-all then freshman, is what I said.
You still call Sandy a know-it-all?
I suppose, yes.
You call her malicious?
Yes.
So you look forward to testifying here in court today?
I look forward to testifying today to tell the truth and make sure that justice is served for Dr. Mans.
You look forward to testifying against Sandy Towns?
I look forward to making sure that justice is served for Dr. Mans.
But Ms. Edwards, in your own words, you're here to see that Sandy gets what you believe is due to her, aren't you?
What is due to her, yes.
Thank you, Your Honor. No further questions.
Any redirect?
Yes, Your Honor. As part of my redirect, may I read Stipulation 5 to the court?
Any objections?
No objections, Your Honor.
All right, you may.
Stipulation 5 states that all officers of the Computer Science Club were deposed and did not deny a quick chat post was made on June 22nd, 2023. However, they do not recall the content. I'll begin now. Ms. Edwards, did your feelings about the defendant influence your testimony at all today?
Absolutely not. I came here to tell the truth.
Thank you, Ms. Edwards. No further questions, Your Honor.
Thank you.
Okay, any recross?
No recross, Your Honor.
All right, thank you. You may step down.
Thank you.
You can give it to the clerk. Does the plaintiff have any other witnesses?
The plaintiff rests, Your Honor.
Okay, the plaintiff rests. Are there any motions before the court, or what's the defense position?
No motions, Your Honor. As brought up in pretrial, the defense asks that there be a brief recess before we begin our case.
All right, the court will take I will grant that application. The court will take a brief recess.
Question recess.
I just want to run to the restroom. Okay, please be seated. Okay, is the defense prepared to proceed?
Yes, Your Honor. The defense calls Ms. Jamie King to the stand.
Okay.
Step up, raise your hand, and you promise to tell the truth.
I do.
Please have a seat.
Permission to proceed?
You may.
Please introduce yourself to the jury.
My name is Jamie King, but I'm Mrs. King to my students.
How did you become involved with this case?
The defense asked me to testify since I know both Sandy and Dalen personally.
Is that Sandy Towns and Dalen Edwards?
Yes,
Let's take a step back for a living. What do you do for a living, Miss King?
I'm a teacher at Athena High.
What drew you to teaching?
Well, there's nothing better than working with bright and young, wonderful people all day. So after completing my student teaching at Athena, I was offered a position in 2009 and haven't looked back since.
What do you teach, Miss King?
I teach AP Computer Science and was the faculty advisor for what used to be the Computer Science Club.
I want to talk a little bit more about your involvement with the Computer Science Club. When was the club founded?
I helped establish the club in 2019 as the faculty advisor.
Why did you decide to get involved?
Well, the computer science industry is booming nowadays, and I thought the club would be a great way for students to get involved and gain some experience on the field. Some of my students have even gone on to study comp sci in college.
How's the club doing now?
Well, not so well. Unfortunately, in 2023, it was defunded and had to be shut down.
How did that impact the club's members?
Well, all the computers that they'd had access to were taken away, except for one. It was sad to see, since it's a little difficult to study computer science without computers.
Do you know who had access to that remaining computer?
Yes. Fortunately, all old members had access to it. I mean, they all use it now.
I want to talk about one of those club members, Sandy Towns. When did you meet Sandy?
I first met Sandy when she joined the computer science club.
And when was that?
That was her freshman year, so wow, it's been 4 years.
Did you ever have Sandy in a class?
Yes, in my AP computer science.
I want to talk about another one of your students, Miss Dalen Edwards. When did you meet Miss Edwards?
Dalen was also part of the club, and she was also in my AP computer science.
How is Miss Edwards involved in the club?
Dalen was actually one of the first to join the club as a freshman, and was both treasurer in 2020 and secretary in 2021.
How did Miss Edwards behave after becoming secretary in 2021?
Dalen became completely unrecognizable. I mean, she became assertive and controlling and created many issues with other members of the club.
Did Miss Edwards continue serving on the club's board?
No, she actually lost the 2022 election to Sandy, who was a year younger than her.
And how did Miss Edwards react to losing that election?
Well, she wasn't very happy, and we talked about it.
What did you and Miss Edwards discuss about the results of that election?
Well, she told me that she was upset, and
Objection, hearsay.
Your Honor, may I be heard?
Yes.
Miss Edwards told Miss King that she was upset. That is state of mind pursuant to mock trial rule 403. This is therefore not hearsay. If I may proffer, I expect that this witness will also offer additional testimony that opposing counsel might believe is hearsay, but I can address that if it comes up.
Okay, they be heard?
Nothing further, Your Honor.
Okay, overruled.
Well, she mentioned that she was upset since she believed that winning the election would have helped her obtain a needed scholarship for her dream school. I tried to explain it didn't work that way, but she just wasn't having it.
Objection, Your Honor. May the witness's answer be stricken as hearsay?
Permission to respond?
Yes, you may.
Your Honor, at the time of making the statement, Miss Edwards was a high school student. Therefore, Miss Edwards had no way of knowing whether procuring this extracurricular would have allowed her to secure this potential scholarship. This evidence regarding Miss Edwards' belief is not being used for the truth of the matter, but rather to show the significant bias that Miss Edwards holds against my client, Sandy Towns, as Miss Edwards blames losing the election to Sandy and believes that had she won the election, she would have received the scholarship.
That could be heard?
Nothing further.
All right, overruled.
I'll re-ask the question. What did Miss Edwards share with you?
Well, she told me that she was upset since she believed that winning the election would have helped her obtain a needed scholarship for her dream school. Again, I tried to explain to her it didn't work that way, but she just wasn't having it.
I want to talk about the reason we're all here today, the deepfakes depicting Superintendent Vance. Are you aware of an investigation into those deepfakes?
Yes, everyone was talking about it. I was actually interviewed for it
When were you interviewed?
in mid-April.
And what did you and the investigator discuss?
Well, the investigator asked me if I noticed any suspicious activity around the computer club room on both April 1st and 2nd.
Had you?
All I noticed was Sandy, which didn't strike me as odd. I mean, she's always there.
What did you observe Sandy doing?
Sandy just popped her head in. I mean, she didn't even step inside.
Did you see Sandy use the computer?
No, I did not.
Finally, I want to talk about the role of generative AI in your AP computer science course. Do your students study generative AI?
Yes, I actually had to write a paper about it. I figured since they use ChatGPT so often, they might as well know how it works.
How would you describe Sandy's understanding of AI?
Sandy wrote a good paper on it and seemed pretty passionate.
What about Miss Edwards? How would you describe her understanding of AI?
Dalen also wrote a fine paper and showed above average sophistication.
What about the rest of your students? How would you describe their grasp of AI?
Well, I do teach a college-level course, so everyone's pretty capable. In fact, there are many students throughout the math and computer science departments that know how to use generative AI.
Thank you, Your Honor. No further questions.
Okay, any cross-examination?
Yes, Your Honor. Your Honor, may I proceed?
You may.
The defendant wrote a paper on generative AI in your AP Computer Science course, correct?
Yes.
And Miss King, you gave that paper an A+, didn't you?
Yes, it was very well written.
The paper showed, by example, how to manipulate old content to create new content. Isn't that true?
Well, yes, that's what I asked of them.
Didn't you discuss AI extensively with the defendant?
Yes, we actually agreed that it's imperative that Congress regulate such a dangerous tool.
So the defendant understands how dangerous AI can be, right?
I mean, sure, everyone does.
So yes, the defendant understands that?
Yes.
The defendant has the ability to produce AI-generated audio recordings, don't they?
Like many of my other students.
And my next question, Ms. King, please limit your answer to just the defendant. The defendant can also produce AI-generated video recordings. Isn't that true?
Yes.
On June 24th of 2023, you examined the remaining computer in the computer club room, right?
Yes, I did.
And on that computer, the descriptive metadata showed a quick chat post was made on June 22nd of 2023 at about 2:30 p.m., right?
That's correct.
The metadata indicates the message was sent to 5 people, right?
Yes, but I wasn't surprised. I mean, Sandy had previously mentioned that she'd sent a quick chat message thanking the members of the committee for their work.
So, Ms. King, you do not dispute that Sandy did send a quick chat message, right?
Yes.
The executive committee was composed of the defendant and 4 other members, right?
That's correct.
After the club was defunded, the computer in the club room was still there for students to use, right?
Yes, thankfully.
And on April 2nd of 2024, you saw the defendant enter the club room around 9:55 a.m., right?
She began to enter but turned around and left.
So when she saw you, she abruptly turned around and left, right?
She was looking for a friend of hers and didn't see them, so naturally she left.
So yes, she abruptly turned around to leave, Miss King?
Yes.
All right. After observing the defendant turn and leave, you left the computer club room to go teach your 10 a.m. class, right?
That's correct.
So, Miss King, you have no idea of anyone entering the computer science club room after you left, do you?
That's right. Anyone could have gone it.
Thank you, Miss King. No further questions, Your Honor.
Okay. Can you redirect?
Very briefly, Your Honor. Ms. King, was Sandy the only student in your class who could have created these deepfakes?
No, of course not. Many of my students had abilities in generative AI.
I want to talk very briefly about your interaction with Ms. King on April 2nd. When Sandy saw you, did she leave the room?
She mentioned that she was looking for a friend and then proceeded to leave.
Thank you, Your Honor. No further questions.
Okay. Any recross?
No, Your Honor.
All right, thank you.
Thank
Sit
you.
down.
The defense now calls Mr. Fran Gates to the stand.
Okay, Mr. Gates, want to take the stand?
Step up and raise your right hand. And do you promise to tell me?
I do.
Have a seat.
Just give me 1 second.
Yes, Your Honor.
Okay, you may proceed.
Good morning.
Good morning.
Please state your full name for the record.
My name is Fran Gates.
What do you do for a living, Mr. Gates?
I'm the technology director for the Helios School District.
Why are you here today?
I'm here today to discuss my investigation into the deepfakes made of former Superintendent Leyton Mans.
Let's talk about your expertise. What is your educational background?
I have a bachelor's in electrical engineering and a master's in computer science from the University of Wisconsin-Madison. Go Badgers.
Do you have any certifications in the field of computer science?
Yes, I have a number of certifications. Bear with me, I know the names are a little weird. One is called Network Plus. I'm a security certified network professional, and I have a certification as a certified AI engineer.
Have you ever worked in the computer science industry?
Yes, my prior employment was as a systems analyst for a large healthcare company in the Midwest, and my current job is as director of technology for the Helios School District.
As director of technology, who's your boss?
I work for the school district, so naturally I report to the superintendent.
Who was the superintendent?
For most of my time, the superintendent was Leyton Mans.
How long did you work with the plaintiff?
I worked with the plaintiff since July of 2014, so roughly 10 years, give or take.
How is your working relationship with the plaintiff?
Professional.
How is your relationship with the plaintiff now?
Still professional.
As director of technology, what do you do?
My job has 4 main parts. I protect against cybersecurity attacks, manage the district's cybersecurity systems, manage the district's technology budget, and I make sure that all the building tech is up to code.
Your Honor, at this time, the defense moves to enter Mr. Fran Gates as an expert in computer science.
Any objection?
Yes, Your Honor, but here.
Yes, you may.
Mr. Gates, even though you have a certification relating to artificial intelligence, you don't consider yourself an expert in the field, correct?
Not in artificial intelligence specifically, but I'm an expert in computer science.
So you don't consider yourself an expert in artificial intelligence?
As I said, no.
Your Honor, we have no objection to his certification as an expert witness in computer science, but we would like to highlight that artificial intelligence is a separate field from computer science, and we would not like it to be included in that certification, as the witness has conceded that he's not an expert in that.
Like to be heard?
Yes, Your Honor. The defense has no objection to that. We are entering Mr. Gates as an expert in computer science, excluding the field of artificial intelligence.
Okay. Application is granted to the extent that he's deemed the expert in computer science.
Mr. Gates, let's talk about your investigation into the deepfakes at hand today. How did you become involved in investigating them?
My employees informed me that a computer at Athena High School could have potentially been misused, so as director of technology, I took it upon myself to go investigate.
When did you begin your investigation?
I began on May 10th of 2024 when I visited the high school computer lab.
Did you find anything when you visited this computer?
I did not, but I know that a VPN could have been used.
What does VPN stand for?
VPN stands for Virtual Private Network.
What does a VPN do?
A VPN masks your computer's IP address, letting you surf the internet virtually anonymously. It's kind of like a ski mask, but for your computer.
Are you aware of any evidence that a VPN was used on this computer?
Yes, trace files belonging to a program called My Secret VPN were found on the computer in the high school computer lab.
What does this indicate?
This indicates that somebody installed the VPN and then removed it.
Mr. Gates, are VPNs allowed on school computers?
No, technically not.
In your experience as Director of Technology, how common is it for students to use My Secret VPN?
Actually, it's incredibly common.
Mr. Gates, how difficult is it to install My Secret VPN?
Not difficult at all. It's a piece of cake. Anybody could do it.
Thank you, Your Honor. No further questions.
Okay. Any cross-examination?
Yes, Your Honor.
May I proceed?
You may.
Good afternoon, Mr. Gates.
Good afternoon.
My name is Maria Triana, and I will be asking you some questions today. You would agree that it is your job as the Director of Technology of the school district to protect it against the misuse of computer systems and computers, wouldn't you?
Yes, I was mainly brought in to combat the emerging threat of ransomware and cybersecurity threats on large networks.
You're familiar with the video that was posted on April 1st about Dr. Mans, correct?
That's correct.
And you're also familiar with the audio that was posted on April 2nd about Dr. Mans.
Of course.
And in fact, you saw these in early April of 2024, didn't you?
That's correct.
And you knew right away that the video was fake. Isn't that right?
That's correct.
In early April, you learned that a computer at Athena High School may have been misused. Isn't that right?
That's what my staff told me, yes.
In fact, you learned of this possible misuse even before you read it in the paper.
That's correct.
At the time, you did not believe that the computer had been misused, did you?
I did not, but I decided to confirm that with an investigation.
Mr. Gates, you're familiar with My Secret VPN, aren't you?
Yes, it's very common among high school students.
Yet, students are not allowed to use VPNs on school computers, are they?
Technically, they're not, but it doesn't really stop them.
So, the use of My Secret VPN on a school computer was a violation of the district's policy, wasn't it?
Yes, theoretically, VPNs on school computers are kind of like the computer equivalent to jaywalking. Theoretically, they're not allowed. Does it happen? Of course.
Mr. Gates, I'm not asking you about theory. I'm asking if the use of My Secret VPN on that computer was a violation of the district's policy. Was it?
Yes, technically it was.
You were responsible for the security of that computer, weren't you?
I'm responsible for the entirety of the network.
Including that computer?
I have staff members that manage the smaller schools in the district.
Your Honor, I move to strike that answer as non-responsive.
Sustain.
I will ask my question again. You were responsible for the computer, for the safety of the computer in the computer science club room, correct?
Sure.
Yet you waited more than a month after the video was posted to do anything about it. Isn't that right?
It was professional courtesy to allow Dr. Roberts to conduct her investigation. Then, as soon as Dr. Roberts' report was released and I was able to consult it, then I did an investigation.
So you waited more than a month?
I did, as a courtesy.
In fact, you're familiar with Dr. Roberts' investigation, aren't you?
Of course I am.
And you looked at the same computer that Dr. Roberts looked at, correct?
Yes.
You don't contradict her findings with regards that MySecretVPN was used on that computer, correct?
Yes, there were trace files belonging to MySecretVPN found on the computer.
You don't know the defendant personally, do you?
No, I can't say I do.
Yet, you read a paper that she authored on generative AI, didn't you?
That's correct. I was trying to familiarize myself with the case.
And you thought that the paper did not demonstrate her ability to produce either the deepfake video or the audio, correct?
Yes, I didn't think it was anything special.
But you're not an expert on AI, are you?
Not AI specifically, but I'm very familiar with computer science.
You're not an expert on AI, correct?
No, I'm not an expert on AI, no.
And you're aware that Dr. Roberts, who is an expert in AI, had a completely different opinion, aren't you?
That's true. Dr. Roberts did come to a different finding than I did.
You're not a fan of Dr. Mans, are you?
I wouldn't say Dr. Mans is my favorite person.
You believe Dr. Mans unfairly blamed you for the failed implementation of the grade track software, don't you?
That's true. I believe he did.
And this failed implementation caused many high school students to not get into their colleges of choice. Isn't that right?
Your Honor, this question is more prejudicial than probative, as this witness has already as Mr. Gates just testified that there was an issue between him and Dr. Mans and that this program didn't work. The details as to how it affected other students not only is not relevant, but serves to prejudice the jury against Mr. Gates for this past error.
Plaintiff like to be heard?
Your Honor, I'm exploring the bias of the witness, and this is an event that can show that partially.
All right, I'm going to sustain that objection. It's going a little too far.
You recommended that software, didn't you?
That's correct. It's generally a very useful software.
You were thrilled to see Dr. Mans resign as superintendent, weren't you?
Yes, I honestly don't think she has what it takes to make a good superintendent.
And you think it's great that Dr. Mans will not be state senator. Isn't that right?
Yes, I don't think she really has what it takes to be a state senator.
And if the video and audio recordings caused Dr. Mans to drop out of the race, then so be it. Correct?
Then so be it, I guess.
You're not sorry that the video and audio were posted, are you?
I don't see why I would have any reason to be, so no.
You don't want us to find out who did this, do you?
I don't really. It's not super important to me.
You don't want us to find out who did this?
If they don't find who did it, then I really don't think it's the worst thing.
Please answer my question with a yes or no. You don't want us to find out who did this?
Sure.
No further questions, Your Honor.
Okay. Any redirect?
No redirect, Your Honor. I ask that Ms. Gates please be excused.
Okay. Thank you. You may step down.
Thank you.
Does the defense have any other witnesses?
Yes, Your Honor. The defense calls Sandy Towns to the stand.
Okay. Can Ms. Towns take the stand?
Raise your hand.
Yes.
Permission to proceed?
You may.
Good morning.
Good morning.
Please state your name for the record.
My name is Sandy Towns.
And why are you here today, Sandy?
I'm here to clear my name. Everything that I've worked for, college, my future, my reputation, is being threatened by the former superintendent, Dr. Leyton Mans. She's accusing me of defamation and claiming that I posted deepfake audio and video of her.
And did you?
No, absolutely not.
We'll talk more about the deepfakes in a moment, but I want to start by having you tell us a little bit about yourself. You mentioned that you're a student. Where do you currently go to school?
Well, this year I'm a senior at Athena High School, but hopefully next year I'll be at MIT or Caltech.
And do you participate in any extracurriculars?
Yes. While it existed, I was a member of the Computer Science Club. It was one of my favorite parts of my high school experience and such a great community, especially for our younger members.
Were you ever on the board of that club?
Yes. I was treasurer my freshman year, and then I moved up the ranks, and I was vice president my sophomore year.
What about during your junior year?
I was elected president, but unfortunately the superintendent cut the club's funding.
And did you ever try to get that funding back?
Of course. I set up a meeting with the superintendent, hoping to get funding back. I wanted to show her how important the club is to the school and to me.
So I want to talk a little bit about that meeting with the plaintiff. When did you and Dr. Mans meet?
June 20th, 2023.
And had you interacted with Dr. Mans prior to that meeting?
I had him personally, but Dr. Mans is unpopular, so a few friends of mine had warned me to be careful around her. They called her ruthless.
And what did you
Okay. I'd like to be heard.
The statement is not being admitted for the fact that Dr. Mans was in fact ruthless. It's just being admitted for the general student body, state of mind, and perception of Dr. Mans.
I'd like to be heard.
Yes, Your Honor, the prejudicial value of that statement outweighs the probative value. She already told us about her feelings of Dr. Mans coming into the meeting.
Your Honor, if I may.
Yep.
The statement does not go to Sandy Town's feelings towards Dr. Mans, but rather the Computer Science Club's feelings towards Dr. Mans. It is the defense's theory of the case that multiple students in the Computer Science Club had negative feelings towards Dr. Mans and had motivations to produce deepfakes in this case. This goes to their feelings, which is more relevant, not Sandy.
Yeah, overrule.
And what did you and Dr. Mans actually discuss?
Well, we mostly talked about these graphics that were produced by a few members of the club. When I tried to tell Mans how important the club was to school, she kept bringing those up. It threw me off because those were 2 years old at that point.
And before Dr. Mans had brought up the graphics, were you aware of them?
I mean, I knew they existed, but I certainly didn't make them, and I don't know which members did. Dr. Mans kept harping on them, even after I made that clear.
And what was the final verdict on the funding?
It was a no. When I asked a final time, Dr. Mans told me that the club members should have thought about that before producing those insulting graphics. I was so disappointed.
Now, Sandy, I want to talk a little bit more about the deepfakes themselves. When was it that you first saw them?
I saw the video on April 1st of 2024, and then I heard the audio recording the next day. That's when they were posted.
And what were you doing when you saw them?
Well, I walked by the computer club room, as I often did since the club had been disbanded. There was a group of students huddled around a computer, so I walked over to say hello, and I saw that they were watching the deepfakes.
And how did they seem to react?
Smiles and high fives all around the room. They seemed elated. I mean, Dr. Mans was responsible for shutting the club down.
And I want to talk now about the investigation that occurred after that. Did the authorities ever reach out to you about the deepfakes?
Yes. Out of nowhere, on April 15th, about 2 weeks after the deepfakes were posted, an investigator from the sheriff's department came to speak with me. I was shocked because it seemed completely out of nowhere.
And what did the investigator ask?
She asked about my meeting with Dr. Mans, specifically if I had a recording of the meeting, so I told her I did.
Did you give her that recording?
Yes, of course.
And was the recording the only thing that you were asked about?
No. The investigator also asked me if I use a VPN and then asked for the name of it, so I told her that I use my secret VPN.
Do you know if other students use this VPN?
Yes, absolutely. It's super popular, mostly because it's free. It's not a great VPN, though. Because it's lower quality, it can sometimes leave your IP address exposed.
Your Honor, I asked that everything after yes be stricken is not responsive.
I'd like to be heard.
Your Honor, if I may, I asked my witness whether or not she knows if other students use this VPN. She's simply clarifying whether or not they do in the extent of that VPN.
I'm going to sustain it after her original answer, initial answer.
Now, I want to get a little bit into the details of what you're being accused of. You were here for the testimony of Ms. Leyton Edwards. Are you aware of claims that you were in the computer club room on April 1st?
Yes.
Were you there that day?
No, I don't think so.
Are you aware of claims about a quick chat message you allegedly sent in June of 2023?
Yes.
Did you send the message that Ms. Edwards claims?
No.
And are you aware of claims that you made insulting graphics of Dr. Manns?
Yes.
Did you make those graphics?
No.
Finally, Sandy, I want to talk about your personal knowledge of AI and deepfakes. Have you taken any classes related to AI?
Yes, of course. I took AP Computer Science.
And what kind of work did you do for that course?
Well, it was a class, so we watched lectures, did some coding, and wrote a paper.
What was that paper about?
It was a synopsis of generative AI, kind of like a history paper. I wrote about AI, showed examples, didn't get too much into the technicalities.
I'd now like to direct the court's attention to what has previously been entered as, I believe, Plaintiff's Exhibit 3, permission to approach the bench to collect.
You may.
Permission to approach opposing counsel and witness.
You may.
Would you like a copy as well?
Yes, please.
Sandy, do you recognize this document?
Yes, this is my paper, an excerpt from it.
How are you familiar with it?
Well, I wrote it for the class.
And is it fair enough your copy?
Yes.
Now, you mentioned that you've written about the dangers of AI. What did that entail?
Well, AI isn't inherently dangerous. I used it to create my breakfast recipe last week. But when it's used for the wrong thing, it can really hurt people and become a problem.
And what are your personal thoughts on the misuse of AI?
Objection relevance.
Your Honor, if I may, this case is about whether or not the defendant, Sandy Towns, my witness, misused AI and committed libel. Her personal thoughts on the misuse of AI are, of course, highly relevant to the case. It goes to whether or not she would actually misuse it in this case and create deepfakes.
Okay. Would you like to be heard?
Yes, Your Honor, but actually, no, Your Honor. I stand by my previous objection.
All right. Overrule.
Sandy, what are your personal thoughts on the misuse of AI?
Like I said, I think it's a real problem. I love computer science, but I hate seeing it used for something like this. You can ask my computer science teacher, Miss King. We talked extensively about how it was imperative for Congress to regulate AI immediately, especially as it pertains to deepfakes.
Your Honor, I asked that everything after DSP be stricken as non-responsive.
Like to be heard?
Your Honor, if I may, I asked my witness her thoughts on the misuse of AI. She didn't answer yes or no, so I'm not sure what counsel's referring to there. But she's simply sharing her belief on the misuse of AI and extending that to her conversation with Ms. King.
All right. Overrule.
And finally, Sandy, did you have anything to do with the production, creation, or distribution of either of the deepfakes at hand in today's case?
Of course not. I hate seeing something that I'm passionate about be used for something like this. I'm being accused of something that I had nothing to do with.
Thank you, Your Honor. No further questions.
Ms. Towns, you turned 18 on October 15th, 2024, correct?
That's right.
And you received your inheritance once you turned 18, isn't that right?
Objection outside of the scope of the direct.
Overrule. I'm giving her some leeway.
Yes, it was for my 18th birthday.
When did Dr. Manns file her complaint against you?
That must have been sometime in May.
It was May 20th, 2024, correct?
That sounds right. I'm not Dr. Manns.
So 5.5 months before you received your inheritance, isn't that right?
That's correct. I received the inheritance when I turned 18, but it was, she knew that I have been related to Jeff Bezos for a very long time, and it was an 18th birthday gift.
Your Honor, I asked that everything after that's right to be stricken as non-responsive.
Defense like to be heard on that?
No, Your Honor.
All right. I'm going to grant the application. Stricken from the record.
Now, you met with Dr. Manns on June 20th, 2023 about restoring the funding to the Computer Science Club, correct?
That's right.
Now, during that meeting, Ms. Towns, you were growing increasingly angry, weren't you?
Yeah, I felt frustrated that Dr. Mans wasn't listening to my concerns.
And after Dr. Mans expressed that they would not restore the funding, you responded by telling Dr. Mans, situations like this don't always end very well. Weren't those your words?
That's not all I said. I said I'm very sorry that Dr. Mans felt this way and that a lot of students would be hurt by her actions. I mean, now there was no club for students to develop their computer science skills.
But just to be clear, you did tell Dr. Mans situations like this don't always end very well, right?
Yes, that's part of what I said.
And right after you said that, you abruptly left the meeting, didn't you?
I did leave, yes.
Now, you recorded this whole conversation on your cell phone, didn't you?
Yes.
And at no point did you tell Dr. Mans that you were recording, did you?
No, I didn't.
And you later copied this recording from your cell phone onto a flash drive, correct?
Yes, that's right.
Even though on your direct you said you made this recording because you were afraid of Dr. Mans, right?
I said nothing like that.
I apologize. Now, Your Honor, may I approach and retrieve Plaintiff's Exhibit 4, the flash drive?
You may.
And may I approach the witness?
You may.
I'm now handing you what's been marked as, or what is Plaintiff's 4. Is this your flash drive that we were just discussing?
Yes.
And that flash drive contains a copy of your meeting with Dr. Mans, doesn't it?
Yes, it does.
Now you can set that aside for a moment, Ms. Towns. 2 days after your meeting with Dr. Mans, so June 22nd, 2023, you sent a quick chat message to the Executive Committee of the Computer Science Club, correct?
Yes, I want to thank everybody for their hard work that year.
Well, you also said in that message that Mans would be taken care of for cutting the club, didn't you?
Yes, what I said was that a higher power would take care of Mans. I knew everybody was upset, and I just wanted to make it clear that, karma gets people.
And Ms. Towns, you also said that this payback would be nice and juicy. You chose those two words, didn't you?
That's what I said, but to be clear, payback, just divine retribution.
Now, in September 2023, there was only one computer left in the Computer Science Club room, correct?
That's right.
But that one computer had the high-tech software that you needed to work on your artificial intelligence skills. Isn't that right?
Yes.
And Ms. Towns, you were able to work on your artificial intelligence skills on that one computer, correct?
That's correct. Me and all the other members of the Computer Science Club.
Your Honor, I ask that everything after that's correct be stricken as non-responsive.
Like to be heard?
Your Honor, if I may, my witness is just clarifying her answer.
All right, overrule.
Now, around that same time, September of 2023, you knew that Dr. Mans was high up in the polls for her state Senate race, didn't you?
Yes, I did.
And Ms. Towns, you were hoping that she would lose that election, weren't you?
Yes, of course. I mean, she was holding a petty grudge against a couple of high schoolers. I can't imagine that's good state Senate material.
And Ms. Towns, you, at this point, you were mad enough to do anything to Dr. Mans. What did you say?
Yes, me and every other member of the club.
Your Honor, I asked that everything after yes be stricken. I asked about the witness's feelings, not the computer science club's.
Like to be heard?
Your Honor, my witness is simply clarifying her answers.
All right, I'm going to sustain that one. I'm going to strike anything after her first initial answer.
Ms. Towns, would you would agree with me that you had a vendetta against Dr. Mans?
Sure, she's not my favorite.
Now, a video recording depicting Dr. Mans was posted on April 1st, 2024, correct?
That's correct.
And on direct, when asked if you recalled when asked if you were in the computer science club that day, you said, "No, I don't think so." Correct?
That's correct.
But really, you don't remember where you were at the date and the time that the video was posted, do you?
That's correct. That was like 8 months ago, so unfortunately, I don't remember where I was at 1 p.m. on April 1st, 2024. Oh gosh, no, that was actually 13 months ago.
But you did, and so I'm assuming you don't recall a conversation with Dalen Edwards that day, do you?
No, which is strange because I would remember talking to Dalen. I try to do it as low as possible.
Your Honor, I asked that that be stricken as non-responsive as well.
Like to be heard?
Your Honor, my witness is clarifying as to why she didn't remember speaking to Dalen on that day.
All right, overrule.
Now, though you don't remember speaking to Dalen, you did have a calculus class at 1 p.m. that day, like Dalen said, didn't you?
Well, I don't remember Dalen saying anything to me, but I did have a 1 p.m. calculus class.
I apologize. Let me rephrase. Dalen testified in court today while you were present that you said you were going to a 1 p.m. calculus class. And you did have a 1 p.m. calculus class that day, didn't you?
I did.
Now, Ms. Towns, you don't recall, an audio recording depicting Dr. Manns was posted on April 2nd, 2024, correct?
Yes.
And you don't dispute stopping by the Computer Science Club room at 9:55 a.m. on April 2nd, do you?
No, I stop by all the time.
Now, Ms. Towns, you use my secret VPN, don't you?
Yes, me and all the other high schoolers.
And you previously wrote a paper on AI about how artificial intelligence can produce new text, images, and video files. Isn't that right?
Yes.
Now, in that paper, you went in depth on generative AI, didn't you?
That's correct. I do that on all my papers. I guess you could say I tried a little hard at school.
Well, specifically in that paper, you showed by example how to manipulate old content to make new content. Isn't that right?
I would hope so, seeing as that was the assignment. Yes.
You would hope so, or you did so?
Oh, I did, yes.
Your Honor, may I approach and retrieve Plaintiff's 5, the report?
You may.
Actually, I believe it's already up there with Ms. Towns. Ms. Towns, is this your report that we were just discussing?
My essay, yeah.
And is that a true and accurate copy of that essay?
Yes.
Your Honor, we offer Plaintiff's 5 into evidence at this time.
Any objection?
No, Your Honor.
All right. Would there be no objection? Plaintiff 5 is in evidence.
Ms. Towns, could you read the sentence on the 4th line out loud? It starts with, "The process is remarkably straightforward."
Yeah. The process is remarkably straightforward. With just a few minutes of source material, such as voice recordings or video footage, anyone can create synthetic media that appears authentic to the average viewer.
Now, could you set that aside and pick up your flash drive, Plaintiff's 4? Now, this flash drive contained a few minutes of source material, like an audio recording of your and Dr. Manns' conversation, didn't it?
This contained a few minutes of audio recording, yes. I don't know about source material.
And you had this recording, this flash drive, containing the recording from June 20th, 2023 until April 15th, 2024, didn't you?
Yes.
No further questions, Your Honor.
Okay. Do you have any redirect?
No redirect, Your Honor. The defense asks that my witness be excused.
Okay, you may step down.
Your Honor, at this time, the defense rests its case and asks for a 10-minute recess before closing statements.
5 minutes.
Yes, Your Honor.
Okay. Okay, please be seated. All right, usually before I begin closing arguments, I always reach out to counsel to see if we got a settlement while we wait.
Unfortunately not, Your Honor.
Okay. So are we prepared to proceed to closing arguments?
Yes, Your Honor.
All right, so we'll start with the defense.
Permission to proceed?
You may.
Today, the plaintiff told me that it was Sandy that had the agenda, the ability, and the access to create these deepfakes. But let's talk talk about what you really heard. You heard that many students in the Helios School District, including every single former member of the Computer Science Club, had the agenda against MANS, had an ability with AI, and had access to the computer that Dr. Roberts claims the deepfakes were uploaded from. The only thing that makes Sandy unique is that the plaintiff picked Sandy from the start. Today, you heard the story of Sandy Towns, an honest and hardworking student who dedicated herself to the Computer Science Club at Athena High School. But just for being a member of that club, Sandy has been an enemy of the plaintiffs from the start. When Sandy dared to question the plaintiff's decision to cut funding for the club, the plaintiff only grew angrier with Sandy, yelling at Sandy and calling Sandy names. So when the plaintiff's campaign failed, she immediately jumped to pinning the blame on Sandy. What then followed was a biased investigation by Dr. Roberts that was focused on Sandy from the start. But not only did this investigation fail to find any evidence linking Sandy to the deepfakes, but also to rule out the countless other students that had the access and the ability to make these deepfakes. Still, Dr. Roberts concluded that the deepfakes were likely uploaded from the Computer Science Club room at Athena High School. Why? Because she was focused on Sandy from the start. I'd like to take a moment to discuss what the law requires. The defense has no burden today. It was the plaintiff's burden to prove Sandy liable by a preponderance of the evidence. That means they had to show it was more likely than not that Sandy committed an act of libel. But the plaintiff has not met her burden. In order to meet this burden, the plaintiff had to show that an act of libel was committed and that it was committed by Sandy. Now, libel has two parts. One, that the defending statement made was false, and two, that that statement was made with actual malice, meaning it was made with knowledge of the falsehood or recklessness as to the falsehood. Now, the defense does not dispute that the deepfakes are false, but the plaintiff has failed to distinguish between the act of creating the deepfakes on the one hand and posting them on the other. If one person created these deepfakes and another person accidentally mistook them to be true and posted it, then neither person committed an act of libel. As you heard from Dr. Roberts today, she admitted that the deepfakes could have been created on a different computer. The deepfakes could have already been on the computer. She told you that the deepfakes could have been emailed to the computer from somewhere else entirely. That means two people could have been involved with these deepfakes. But only if one person created and posted these deepfakes or posted them with knowledge of their falsehood did they act with actual malice. This is what the plaintiff had to prove with clear and convincing evidence, where they have simply offered none. The plaintiff has not met her burden. In the alternative, even if you believe the plaintiff's assumption that one person created and posted these deepfakes, the plaintiff has also wholly failed to prove that Sandy had anything to do with these deepfakes. Today, the plaintiff offered no direct evidence and instead attempted to rely on circumstantial evidence to prove her case. But in order to prove her case using circumstantial evidence, the plaintiff had to show that each of the circumstances pointed to Sandy by a preponderance of the evidence. Yet the circumstances that opposing counsel has presented are so vague. A recording of the plaintiff's voice that anyone could have, access to an open computer, and a grudge against the plaintiff who admits she was not well-liked, these things could apply to anyone. In fact, the plaintiff's whole case only makes sense if you approach it with the same attitude that she did and pick Sandy from the start. Because as the plaintiff told you today, she blamed Sandy the moment she saw the deepfake recordings and never considered another option. Dr. Roberts' investigation followed this exact same path and was focused on Sandy from the start. So let's talk about that faulty investigation. Dr. Roberts' investigation is a classic case of confirmation bias. You heard today that Dr. Roberts immediately focused in on one computer, the computer in the computer science club room at Athena High School. She told you that she did so because she knew that Sandy had a recording with the plaintiff's voice. A recording Dr. Roberts told you she didn't even open.
The plaintiff also told you that she was a public figure running a highly publicized political campaign, meaning that every student in the Helios School District had easy access to recordings of the plaintiff's voice.
In fact, every single student in the Helios School District could have had a recording of the plaintiff's voice, and Dr. Roberts has no way of knowing. When Dr. Roberts investigated the computer in the computer science club room, she found that a VPN called MySecretVPN had been used on April 2nd. Using no other evidence, Dr. Roberts concluded that MySecretVPN was probably used on April 1st too, a conclusion that, while convenient, has no basis in scientific reasoning. What Dr. Roberts testified she knows for certain, though, is that MySecretVPN is ubiquitous among high school students. So Dr. Roberts found MySecretVPN on a high school computer. MySecretVPN may well have been used on every single computer in the Helios School District, and Dr. Roberts has no way of knowing. That's because Dr. Roberts' investigation was riddled with bias. You heard today that she is still furious that Sandy's family cut her out of a multi-billion-dollar business, and that when it comes to Sandy, she thinks that the apple doesn't fall far from the tree. After all, Sandy recently came into a large inheritance from her family, the same money that Dr. Roberts feels she was robbed of all those years ago. Dr. Roberts reached the conclusion that she did because she was never really investigating who made these deepfakes. She was focused on Sandy from the start. Because the plaintiff picked Sandy from the start, she conveniently overlooked the person who did make these deepfakes. Undoubtedly, someone with skills in computer science, access to a Helios School District computer, and a vendetta. But the plaintiff's assertion that this person could only be Sandy falls apart when you realize that, just for example, one of the plaintiff's own witnesses, Miss Edwards, also fulfills all these requirements. Miss Edwards took a college-level course in computer science, and you heard from Miss Edwards' teacher, Miss King, that Miss Edwards demonstrated an above-average capability with generative AI. Miss Edwards was also a former member of the computer science club, and just like any other former member of the club, she had access to the club's computer whenever she wanted. You also heard that Miss Edwards despises Sandy because she blames Sandy for ruining her chance to go to her dream school. Now, Miss Edwards claims that she saw Sandy outside the computer science club room on April 1st. But Miss Edwards also told you she only conveniently remembered that after that she learned that that room was being investigated by the county sheriff's department. Even if you take Miss Edwards at her word that she saw Sandy outside the computer science club room that day, it begs the question, what was Miss Edwards even doing there in the first place? Miss Edwards also conveniently remembered receiving a quick chat message from Sandy almost a year before the deepfakes were posted. But Miss Edwards also told you she doesn't remember exactly what that message said, exactly when that message was sent, or have any evidence of having received this message. In fact, she didn't tell anyone about it until she reported it to investigators almost a year later. Members of the jury, I want to be very clear. The defense does not have a burden to show that Miss Edwards, or anyone else for that matter, created these deepfakes. But the fact that all the evidence opposing counsel has presented could also be applied to Miss Edwards shows that they have simply not proven Sandy liable by a preponderance of the evidence. The plaintiff has not met her burden. Because as you heard today, Miss Edwards isn't even the only person that the plaintiff's evidence could be used against. Take Sandy's AI ability, for example. You heard that out of the 6 witnesses in court here today, 5 of them have abilities with generative AI. You also heard that Dr. Mann was supremely unpopular and disliked by every former member of the computer science club. The same computer science club that had access to the computers Dr. Roberts told you the deepfakes were uploaded from. So then, why Sandy? Why did the plaintiff pick Sandy from the start? Well, the plaintiff told you herself. She despises Sandy just for being a member of the computer science club, and when Sandy dared to question the plaintiff's decision to cut the club's funding, the plaintiff only grew angrier with Sandy, screamed at her, and called her names. The plaintiff also told you she knows Sandy recently came into a $2 million inheritance. Members of the jury, that's 2 million reasons to sue. As the plaintiff herself put it, she looks forward to collecting a big chunk of that money. Members of the jury, the plaintiff made up these allegations against Sandy the same way she made up facts for you on the stand today. The plaintiff wanted you to believe that her campaign was doing well so badly that at first she lied and told you that she had conducted polls in 2024. Then, when I brought up her affidavit, she suddenly changed her tune and agreed that she hadn't conducted a poll since 2023. The plaintiff can't even keep her story straight. So how are we supposed to believe that story? The plaintiff had every motivation to target Sandy and tried desperately to find evidence to back up this assumption. But the vague circumstantial evidence that opposing counsel has presented today does not point to Sandy. It could be used to accuse any number of students in the Helios School District. It could be used to accuse any former member of the Computer Science Club. It could be used to accuse the plaintiff's own witness, Miss Dalen Edwards. The only thing that makes Sandy unique is that the plaintiff picked Sandy from the start. But the plaintiff's decision to target Sandy Towns certainly does not mean that she committed an act of libel. We ask that you find Sandy Towns not liable. Thank you.
Thank you. Does the plaintiff wish to proceed with closing arguments?
Yes, Your Honor. Your Honor, before I proceed, may I approach and retrieve plaintiff's fort, the flash drive?
Yes. Okay.
May I proceed?
You may.
Your Honor, we're here today because the defendant, Sandy Towns, defamed Dr. Leyton Manns by producing and posting deepfake video and audio recordings of Dr. Manns engaging in criminal conduct and disrespecting her constituents. This was a calculated and successful undertaking to ruin Dr. Manns' state senate campaign, career, and reputation. I'd like to take a brief moment to quickly address some of what you just heard from the defense. Mock Trial Rule 702 states, questions on cross-examination should not seek to elicit fact that is not contained in the fact pattern. If a witness is asked such a question, they may invent fact. Opposing counsel broke that rule by asking the plaintiff if she had conducted polling after November 2023. The silence of the affidavit reflects not on the witness's knowledge of the facts, but on opposing counsel's question. Now, opposing counsel also says that it was just Sandy from the start, that there were 2 million reasons to sue, that the defendant's whole motive, the plaintiff's whole motive for the suit was the defendant's inheritance. Your Honor, that inheritance came 5.5 months after the plaintiff brought her suit. The plaintiff holds the burden of proof in this morning's proceedings. Defamation, according to Messina v. Healthcare Insurance Company, is a false statement which exposes a person to public contempt, ridicule, aversion, or disgrace. Messina also establishes that when the plaintiff is a public figure, which Dr. Manns is, we must also show that the statement at issue was made with actual malice. Actual malice is defined by the Supreme Court in New York Times v. Sullivan as either knowledge as to the falsehood or reckless disregard for the truth. And with those standards in mind, let us examine the course of events that the evidence has revealed. Let's start from the beginning. Dr. Manns was a lifelong public servant of Presiding, New York. She went to high school and college there and spent 34 years in their school district, the last 17 of which as superintendent, and the last 8 of which while also serving on their county legislature. In 2022, Dr. Manns decided to run for state senate, and so she announced her retirement from the district, effective at the end of the 22-23 school year. Dr. Manns' last act as superintendent was to create the budget for the upcoming year, and in light of the tax revenue shortfall, Dr. Manns made a difficult but necessary decision. Cuts around the district, including cutting the computer science club at Nottingham. The defendant, then president-elect of that computer science club, met with the Superintendent Manns on June 20, 2023 in a last-ditch effort to get the funding restored. When Dr. Manns said no, the defendant reacted by threatening her, saying, "Situations like this don't always end very well," before storming out of the meeting. 2 days later, the defendant sent a quick chat message to the executive committee of the Computer Science Club and by accident included Dalen Edwards. Now, Dalen told us what that message said. That the defendant would make Dr. Manns pay for cutting the Computer Science Club, and that no one would vote for Dr. Manns after seeing the nice Rick Rock video and juicy audio recording. Now, the defense says that Edwards conveniently made this up. First of all, it's stipulated, too, that every other executive committee member saw a message from Towns that day. Moreover, the defendant herself told us that she sent a message containing a statement that Manns would be taken care of for cutting the club, and that this retribution would be nice and juicy, the same 2 words that Edwards recalled. Now, a few months later, Dr. Manns' state senate campaign is in full swing. She's well up in the polls and confident that she will secure the seat. Until April 1st, 2024, when a deepfake video was posted on Rick Rock depicting Dr. Manns accepting a $50,000 bribe to build a new elementary school. The next day, a deepfake audio was posted on set depicting Dr. Manns making disturbing and disparaging comments about many of her past employees and current constituents. Your Honor, those were the nice Rick Rock video and juicy audio recording that the defendant had promised. Presiding turned on Dr. Manns. Her state senate campaign didn't make it a month. On April 30th, Dr. Manns officially suspended her campaign. That very same day, Your Honor, Dr. Roberts' report was released to Dr. Manns, exposing the recordings as deepfakes and fully exonerating Dr. Manns. But it was far too late. Far too late. Your Honor, there is overwhelming evidence that the defendant created and posted the deepfake recordings. First, there was the threat in the meeting. Then the declaration of intent in the quick chat message. Moreover, on the stand today, the defendant admitted that they have a vendetta against Dr. Manns. Edwards did it. That they knew Dr. Manns was high up in the polls of September 2023 and wanted Dr. Manns to lose. Edwards didn't. And that the defendant admitted she was mad enough to do anything, Your Honor. Now, Jamie King, the defendant, Professor Roberts, all told us that the defendant has the ability to generate the deepfake audio and video recordings. The defendant herself then told us that she can make such recordings from, quote, just a few minutes of source material, like an audio recording. You may remember the defendant kept this flash drive, Plaintiff's Exhibit 4, containing a few minutes of source material, like an audio recording, for 10 months, until well after the deepfakes were posted. Dr. Roberts, professor of computer science and certified by this court as an expert in AI, told us that the contents of that flash drive were more than sufficient to create the deepfakes in question. Now, Dr. Roberts also tied the deepfakes to the computer in the computer science club room and determined with absolute certainty that someone had used my secret VPN on that computer. Now, the defense contests these findings, but they brought an expert in computer science, not AI. They attacked Professor Roberts personally and attacked the style of her investigation, but, Your Honor, they had no response to the findings. The defendant admitted to using the computer in the computer science club room to work on her AI skills and to using my secret VPN. Dalen Edwards saw the defendant rushing out of the computer science club room at 12:55 p.m. on April 1st, moments before the deepfake video went live. Jamie King places the defendant at the computer science club room at 9:55 a.m. on April 2nd, right before she left the room for an hour and right before the deepfake audio went live. Your Honor, the defense spoke at length about circumstantial evidence. But to quote Mock Trial Rule 903, the law draws no distinction between direct and circumstantial evidence in terms of either weight or importance. Either type may be sufficient to establish liability. The defense also says that we failed to meet our actual malice burden. Your Honor, deepfakes inherently meet that burden. The defendant created these recordings to make it seem like Dr. Mann said and did things that never happened. That means both knowledge as to the falsehood and reckless disregard for the truth. The evidence is clear and convincing that the defendant, and only the defendant, could have produced these recordings. The defendant had a vendetta and was mad enough to do anything. The defendant had the necessary skill, the necessary material. They admitted to using the computer that the deepfakes were tied to. They were witnesses, placed them at the room the deepfakes originated from moments before each went live. The defendant made a threat and followed through. Your Honor, the law placed a burden upon us this afternoon, a burden which we have met. In light of the evidence before you today, the plaintiff asks that the court sustain the complaint and find that Sandy Towns defamed Dr. Leyton Manns. Thank you.
Thank you, Counselor.
So, good morning, or is it afternoon? So still morning, everyone. My name is Oliver Young, and I chair the mock trial subcommittee of the Law, Youth, and Citizenship Program of the State Bar Association. And once again, we want to congratulate all 8 teams that competed yesterday in this competition. And especially and a special congratulations to the 2 teams that competed this morning. The subcommittee is the organization that prepares the mock trial case materials every year, and we really enjoy preparing the materials, but we enjoy even more seeing the teams and the students perform these cases. So we really appreciate that, and thank you for participating. Now, let me tell you a little about the outstanding judge that presided over this matter. The judge is the Honorable Eddie J. McShan. Now, Justice McShan is an Associate Justice of the Appellate Division of the 3rd Department, one of the 4 courts that are just below the Court of Appeals, which is the highest court in our state. He is a graduate of St. Lawrence University, the Maxwell School at Syracuse, and Syracuse Law School. He served as a law clerk to Bronx Supreme Court Justice Torres from 1998 to 1999, and to Justice Martin 1999 to 2008. His judicial career began in New York City Civil Court from 2013 to 2018, and as an acting Supreme Court Justice from 2016 to 2018. Justice McShan was elected in 2018 as a Supreme Court Justice for the 12th Judicial District. And he's here in the Appellate Division being placed on 3rd Department Court. And Judge McShan, believe it or not, runs a mock trial program. And it is called the Thurgood Marshall Jr. Mock Trial Program. So the judge is very well aware of what you've gone through for the last 3-4 months, and appreciate you being here and participating. And now we're going to hear from the judge, and then he'll give his ruling. So, Judge McShan.
All right, congratulations. I mean, phenomenal job. Like it was mentioned, I do run a mock trial program, but it's for junior high school students, and I hope they can perform when they get to the high school level as excellent as you guys did today. I mean, you make my job so very difficult, determining whether or not Sandy Towns is liable. Incredible job. And when I tell you, you guys you fooled me. I thought I was in the actual trial. I thought I was actually looking at witnesses and lawyers presenting a defamation case. So I just want to congratulate both sides on a job very well done. Let me start with the witnesses. Each of the witnesses had a strong grasp of the facts. I mean, you guys knew your roles better than anyone could have. I really thought we had an expert witness. I really thought we had an ambitious defendant over here, Miss Towns. Every witness put on a great performance. It was very difficult to distinguish between a 5 and a 4. Everybody got at least a 5, at least a 4, and it was very hard to say who got a 5 and who got a 4. But great job to each of the witnesses. I want to give each one, because the witnesses play a very important role in the mock trial. They don't get the credit that the lawyers get, but the witnesses do have a great role in the mock trial program because their scores can really determine the outcome of the case. So let's give a round of applause to each of the witnesses. Now for the attorneys. Phenomenal. Before I announced the score, I may have to get walked out to my car because it was very hard to determine which one of you guys did a great job, because all of you guys did a phenomenal job. Very well prepared, excellent direct examination questions, excellent organization. Cross-examination was brilliant. You guys listened to the answers. You guys responded to the answers that were given by the witnesses. Attorneys don't do that. Sometimes attorneys come to the courtroom and they have a script, and they don't really listen to the witness, what their answers are, and then they'll go on to their next question with missing a perfect opportunity to address something. Each of you listened to the witness's testimony, and I must say it really is indicative of your analytical skills, and that's part of the analytical skills is really listening, your reasoning skills, and you guys have that. I mean, I'm expecting to see hopefully I'll be retired by then, but I'm expecting to see most of you guys in the courtroom very soon, and soon to be our future judges. So opening and closings, man, it was really hard to say who got the upper hand on those. I mean, you guys were phenomenal. So I just want to congratulate you. So despite who wins the competition, everyone did a phenomenal job. Congratulations, and I'm very happy to have judged this competition. After a very close competition, I'm going to have the attorneys rise. I'm going to have the witnesses rise. Please stand up. All right, in the case of Mans v. Towns, the court finds that Ms. Towns is liable, and I will give the award to the plaintiffs. Great job, both sides. Okay. Now let me get out here before I get in trouble.